having taken an oath to support the Constitution.
Let's do the time warp.
So even though everybody at the time knew that Section 3 disqualified Jefferson Davis to be president, you don't think that's good enough evidence to take a position as to whether or not the presidency is an office that is covered by Section 3?
No, because this is a matter of active scholarly dispute. Professor Lash, and Professors Blackman and Tillman do not think that the language which the two senators here are discussing comprehends the office of the presidency.
And they also don't think it's enough that the presidency is referred to it as an office about a dozen times in the Constitution. Let's talk about oaths.
I just walked in.
I believe you testified on direct that you thought there's a difference between an oath to support the Constitution of the United States and the president's oath. Do you recall that testimony?
Yes.
And I believe you said that the president's oath to preserve, protect, and whatever else it says isn't an oath to support the Constitution.
Did he say that, whatever else it says?
And it's in a different article of the Constitution as well.
I love all
Okay, it's preserve, protect, and defend the
life.
Constitution, right? That's what the president has to do?
That is, he is required to take that oath, and having taken it to carry it out.
And they use different words, but you would certainly agree with me that preserving, protecting, or defending the Constitution of the United States as a practical matter includes an obligation to support it, right?
I don't think it is relevant whether as a practical matter, it requires to support the Constitution. As a practical matter, sure, but we're not talking about practical matters. We're talking about the actual
I love it,
language
Lee.
of the Constitution, the actual language of.
I want to read that. I'll find that, Lee, and get the link.
Powerfully different from the
Breaking news. Mark Meadows, well, this is an hour ago, I think.
And sir, are you going to take the position?
An hour ago.
Well, strike that.
Mark Meadows, book publisher,
Preserving,
sued him
protecting,
today
and
for lying in
defending
his
the
book.
Constitution
They
of the
want
United
all their
States
money back, plus
may
over
not be
$1 million
limited
in,
to
quote,
supporting it,
reputational
but
damages
certainly
they suffered by
includes
being
supporting the
associated
Constitution,
with
right?
him. Hoo, hoo. I gotta put that up
As
there.
a practical matter, yes, but again, I don't see the real relevance of that because the constitutional language is crafted carefully and precisely so as to achieve the intended objects. And I do not believe that the framers of Section 3 were careless in their draftsmanship. It may be that there are some formulations of the Articles 6 oath or its equivalent that vary linguistically slightly, but there's a palpable difference between the language of the Article 2 oath and the language of the Article 6 oath. I think that linguistic difference, which is a substantial one, supports the view that the president is not comprehended under the disqualification language of Section 3 because he does not take an oath which members of Congress do.
Wait,
Support
the president doesn't take an oath?
It's a different oath, and has ever since George Washington was inaugurated in 1788. And I think the framers of the Section 3 understood that perfectly well.
Sir, we talked about dictionaries earlier, and you testified on direct that in some of the historical research you've done in the past, you've looked at a dictionary by Samuel Johnson. Do you remember that?
The best of my recollection, yes.
And you cited Samuel Johnson because that dictionary in the late 1700s was considered kind of one of the gold standards for lexicography and definition, right?
Yes, it's maybe not unique, that dictionary of English language.
All right, so let's pull up Petitioner's Exhibit 280. This is Samuel Johnson's 5th edition,
I'm gonna nail this guy.
which I will represent to you is from 1773. And I want to look at how Samuel Johnson defined
I want
defend,
to come to Michigan.
that word that appears in the Article
I'm not
2
going to put
oath,
where you guys
okay?
are on the screen.
Defend, to stand in defense of, to protect, to support. Do you see that, sir?
Yes.
What's the oath they take when they stand up and put their hand on a Bible on Inauguration Day? I'm confused. I know that's swearing them into office, but don't they take an
I want to
oath?
go back to our Section 3. Your position is that you're not going to tell us whether the presidency is an office under the United States, but you know that the president is not an officer of the United States. Is that your testimony?
I am very confident that the president, for this purpose, is not an officer of the United States, and I rest that position on the occurrence of that term, that specific term, that exact language, in other parts of the Constitution and judicial interpretation.
Which part?
That language and other parts.
Show us the part.
From
I will. I can do it. I know. You guys get the lake effect.
In the free enterprise case, there's a consistent body of judicial opinion from the Supreme Court and other lower courts concerning the meaning of officer of the United States elsewhere in the Constitution. Some of that case law is around the time of the ratification of Section 3.
Okay, sir. And you talked about some case law on direct examination as well. And I believe that you said that some of those cases were about the appointments clause, which you said was the anchorage of the meaning of the phrase officer, right?
Yes.
Let's look at the appointments clause. Our Constitution again, on page 7, the appointment clause says that the president shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers
I
and
went to
consuls,
Milwaukee.
judges
I
of the
love
Supreme
that.
Court, and all other officers of the
Yeah.
United States, correct? And the president can't appoint himself, right?
No. That's because he's not an officer of the United States.
Well, he's certainly not an other officer of the United States, right?
Well, not being an officer of the United States, he can't be another officer of the United States.
Right, but if we're talking about the appointments clause, and the appointments clause is talking about other officers of the United States, clearly the appointments clause couldn't cover the president, even if he was an officer, right?
Well, let me refer again to Chief Justice Roberts' opinion in the free enterprise case, where he explains the language that's the issue right now.
Oh,
in the
100% annoying.
This, that the Constitution
100%.
establishes
Yes, snowbird it
quite
up.
clearly, distinction. It's a fundamental distinction.
Hi,
in the
Tom.
Constitution
Welcome.
between
You're fine.
those
I
who are
was late.
elected to their offices
He's being grilled on cross, Clay. He's
and those who are appointed
discovering that
to
all
their
his body of
offices,
work
like
means
Secretary of
nothing.
State or Chief Justice.
He's going to die on a hill for an orange man.
And that's why that fundamental constitutional distinction, which is reflected here between elected and appointed, that's recognized and established in the case law.
All right, so let's look at that. I want to look, let me ask you this first. You know that President Trump has previously argued that he is an officer of the United States, correct?
I do not know that, but if I wanted a constitutional interpretation of that language, he would not be the first person I'm not.
Fair enough, but let's look at it anyways. Petitioners Exhibit 287. I'm showing you President Donald J. Trump's memorandum of law in opposition to the people of the state of New York's motion for remand. Do you see that on your screen? Okay, and the way this case came up is that there was a criminal prosecution of President Trump that then got removed to federal court. President Trump tried to remove it to federal court. And then the district attorney of New York tried to remand it back to state court,
Oh, there was
right?
a lot about him. Yes, it's cross though, JT1C.
Okay, if we go to
At least
page
it's cross. It's much more
8.
entertaining.
Legal argument. Point 1 The president is an officer of the United States who can remove cases to federal court. Do you see that? Later on, and this is page 2 of the motion itself, numbered page 2, there's a citation to Josh Blackman and Seth Barrett Tillman. And do you imagine that those are the same scholars that you had cited in your direct testimony?
Yes, they're the same.
And President Trump says, well, this argument that elected officials, including the president, are not officers of the United States has been advocated by these professors for some time. To our knowledge, it has never been accepted by any court. Do you see that?
Yes.
And if we go to the next page, well, actually at the bottom of this page, there's a footnote 1, and they're citing some articles. And then the footnote continues on page 2. And President Trump
Same
says,
mayo jar.
to be clear,
It's the
we mean
same-
no
it's the
disrespect
same mayo jar.
to either of
Hi,
these
Lily.
fine
Hi,
academics, but their views
Hi,
on this
Lily.
matter are idiosyncratic.
Sorry, I'm late.
CEG, our
Traffic's
next
terrible in
president,
Los Angeles.
at 5 through 6, collecting the contrary views of numerous scholars and of limited use to this court. Do you see that?
Yeah.
Did you know that this brief also specifically addresses the free enterprise case that you were just talking about?
No, I have not read the New York Times.
I haven't read that. I don't read stuff.
Well,
I did. I
on the
just
next
ran
page,
in.
page
I'm so
4,
sorry.
there's a citation to Free Enterprise Fund, and that's the
Oh,
case we were
God.
just referring to, right?
Yes.
And it says that case addresses the president's removal power under the Article 2 Appointments Clause.
Yes.
And then it says later, it is clear that the Supreme Court was not deciding the meaning of officer of the United States as used in every clause of the Constitution, let alone in every statute of the United States Code. Rather, the court was simply describing the meaning of other officers of the United States as used in U.S. Constitution, Article 2, Section 2, Clause 2. Do you see that?
Yes.
And then that paragraph goes on to say, obviously the president cannot appoint himself, and so other officers of the United States,
This pretty
as
much
used in Article
captures the
2,
entire
Section 2,
section.
Clause 2, must be a reference to non-elected officials, right? And then President Trump says, this stray line in Free Enterprise Fund says nothing about the meaning of officer of the United States in other contexts, such as the relevant context this court must consider here, correct?
Yes.
I want to take us back to the 19th century now.
Did you want me to speak to this?
No, your counsel can ask you questions about that if they'd like. Let's go back to the 19th century. Petitioner's Exhibit 144 again, Magliacca's materials. And we're going to go back
I love this
to-
lawyer so much.
Attorney General Stanberry's first opinion.
Yes.
You're aware that he also addresses officers of the United States, correct?
In the statutory context.
Yeah, in the context of the Reconstruction Act's applying Section 3 disqualification.
Yeah.
And Attorney General Stanberry says, this brings me to the question, who is to be considered an officer of the United States within the meaning of the clause under consideration? Here, the term officer is used in its most general sense and without any qualification as legislative or executive or judicial. And I think as here used, it was intended to comprehend military as well as civil officers of the United States who had taken the prescribed oath, correct?
Yes.
And did you know that Attorney General Stanberry also addressed the meaning of officers in his second opinion?
Yes.
Page 811, excuse me, page 814, officers of the United States.
Exactly.
As to these, the language is without limitation. The person who has at any time prior to the rebellion held any office, civil or military, under the United States and has taken an official oath to support the Constitution of the United States is subject to disqualification. Do you see that? So here, Stanberry isn't
No, we
drawing
just
a
started,
distinction
Diana. We just
between officers
Traffic was
and
terrible.
those who hold offices, correct?
It's amazing.
Not that I can see.
Did you know that Attorney General Stanberry also referred to the president as an officer?
I said that, though he wasn't there purporting to interpret the language of Section 3. My recollection is that he said that
My
the
recollection.
military governor of not.
Sir, I think we've proven that your recollection sucks balls.
Usurp powers that were not his, would be placing himself on a higher footing than the president, who is, if I remember the language, not to be considered, who is merely an executive officer of the United States. I think that's what it says. It doesn't appear on the screen. But
Sorry, I'm gonna get some Thai food. Oh, gal!
Statute
Hooray!
in line with what he says elsewhere.
Yeah, and your opinion, or what you just said, you quoted it spot on, and that was from this same second opinion on the Reconstruction Act, correct?
Yes.
Oh. I don't know. He did comb his hair.
Andrew Johnson was president when the 14th Amendment was ratified, right?
But
Yes.
let the lawyer give you life, Steve.
And he also issued other presidential proclamations, correct? And in some of those proclamations, Andrew Johnson referred to himself as the chief executive officer of the United States.
He referred to himself as the chief executive officer of the United States.
Do you know whether other presidents during the 19th century were referred to as the chief executive
wanna
officer of
come
the
up,
United
hit the link.
States?
You don't have to, though, obviously.
In the 19th century, it was a common way to refer to the president, to refer to him as the chief executive officer of the United States. You would agree with that?
A common way, not common in connection with the interpretation of the appointments clause, however. And indeed, the chief executive officer of the United States is a different term colloquially from the term officer of the United States as used in various places in the Constitution.
Exactly.
Article 2's appointments clause. So I don't consider that evidence of it's not really terribly relevant, if it's relevant at all, which I doubt, to an interpretation of the Constitution in any of its parts that uses the term officer of the United States.
So
I think that the focus needs to be not on how officer or
Okay,
officer of the
this
United
means
States
Oomph is really
misunderstood in statutory context.
If he starts
in
to
official
swear, we know
proclamations,
this guy's cost a line.
colloquial usage. The question before the court is, how is it understood for purposes of the framing, ratification, and later understanding of Section 3 legal terms?
It's a perfect
and
double
ordinary
hunting.
uses
I love
of
it.
language cannot simply be mapped on to constitutional language.
Okay.
You don't think it was relevant in interpreting the phrase officer
I wouldn't
of the
choose
United
officer.
States as used in Section 3 in the 1860s to look at what people in the 1860s thought officer of the United States meant?
Not given the language of the original Constitution of 1788. No, I do not think it is particularly relevant at all. It's the legal term, constitutional term of art.
Friday, might as well.
Let me give you an
And-
example of what I.
No.
Well, let me ask you a question, sir,
No,
and then
my
you can
questioning
answer my
time,
question.
bitch.
So you wouldn't think it was relevant that
Oh, Section 3, that's a good one.
Presidents Jefferson, Jackson, Van Buren, Harrison, Polk, Taylor, Fillmore, Buchanan, Lincoln, Grant, and Garfield were all also referred to as the chief executive officer of the United States.
I don't. And let me give you an example.
No,
I'm just gonna, that was just a yes or no
Railroad
question.
you.
If you want to expound, I'm sure your counsel can follow up on
oh,
it.
here, Sorry.
Well, particularly.
God, I'm
And
not
therefore,
very
you
smart.
didn't look at any of that historical evidence in your report,
The
correct?
Constitution says what it says, and you interpret one clause of the Constitution in connection with other terms.
Get ready to
that
be
use
hammered.
the
Don't
same
drive.
language or
Don't drive and watch this.
extremely close.
I know, Rogue's on
Okay,
a
but you
roll.
would agree with
He had a
me
good lunch.
that the original Constitution was ratified roughly 80 years before Section 3 of the 14th Amendment, right? Okay, right now we're in the 117th
Ooh.
Congress. Do you know
I wish I
which
drank, 'cause I
Congress
like
was the
cider.
Congress that enacted
But I don't drink.
legislation proposing ratification of Section 3?
It was proposed in 1866.
And what number Congress was that?
I don't remember.
You're not aware that it was the 39th Congress, one of the most famous Congresses in American history, that proposed Section 3?
Well, I'm grateful to be reminded.
And so you also didn't think it was relevant that the 39th Congress repeatedly referred to the president as the chief executive officer of the
Good
United
idea.
States.
Again, I don't think it's particularly relevant. I mean, may I find you an example that I mean to understand?
Hi, holy fuck.
What's up with the green water?
Article 2.
What is
that?
green water?
Yeah, what's that?
Is
Is
it shall advise and consent
Electrolytes?
to presidential nominations to certain offices, and the Senate shall advise and consent to treaties. Well, if you took those words, advise and consent, in their ordinary meaning, outside the context of the Constitution, then the Senate would have to consent to every
Crazy.
treaty and consent to every presidential nomination. The Senate doesn't always consent to treaties or nominations, right? So I deduce from that that the term advise and consent was a term of art as used in the Constitution. My recollection, I never studied this deeply, but my recollection is that the term advise and consent was used as a term of art in English law, and then entered our Constitution in 17.
Oh, yeah, it's what's that called? Midori? That green liqueur?
That was the
It tastes like
real
shit.
I think he's getting ready to do an Orson Welles wine commercial. He's gonna be like, told you, there's no wine before it's time.
Those words having common acceptation.
Mostly gin. Gin and
And because of
Midori.
your view about constitutional interpretation and methodology, you didn't think it was relevant to see how the 39th Congress that enacted the 14th Amendment used the phrase officers of the United States,
Genital
correct?
attorney.
Not particularly.
Attorney genital, that's it.
And so if I were to show you 10 pages from the Congressional Globe of the 39th Congress that repeatedly referred to the president as an officer of the United States again and again and again, and these were the very same people who enacted Section 3 of the 14th Amendment, you wouldn't think any of that was relevant, would you, sir?
They're proposing the language.
He drives a van.
as backup of the Constitution.
Let's
that
start
had been in
rumors.
existence for 80 years. And as that constitutional language would have been understood even before it was public.
So there's some sort of
Does everybody get
technical
drunk at lunch?
term of art meaning in the phrase officers of the United States that was different from the way that everybody was actually using those phrases in public during the ratification or during Reconstruction. That's your testimony?
No, I don't want to characterize it.
All right, I have no further questions. Thank you.
My questions are going to be less than that, Your Honor.
I know, but I think she needs computer service.
Oh, that's non-negotiable 5 minutes. I understand, Your Honor.
Yeah. Well, I mean, Chester the molester on the stand. I'm just saying. We're on a break?
Jeez.
Oh my gosh, how many breaks?
So many breaks.
Ugh.
Everybody poops.
I think that's yours.
Everybody poops. Oh, hi everybody. Welcome back. Hi Jim. Hi Gal.
Hey,
Hey. We
What's
just
What
it?
up?
we just got here, and they are
and they're already leaving.
and the
That's
mayor. So, is there somebody else coming up?
well, there has to be.
Tim
'cause-
Hafey. Tim Hafey. Tim Hafey.
Oh, so we haven't missed him. I think we're going to do a little bit of trivia tonight. I don't want to miss that. So I'll take a nap and then I'll come back and we'll do some trivia. Because I think they end around, well, I don't know. I thought she said something special about ending today. What is with that woman's hair? Dude. Oh, it's a mask. Okay, sorry.
She has a mask on.
Sorry, I'm
Jeez,
sorry. I thought it was
Lolo.
a hair band and I thought it
Golly, girl.
God. Girl, I thought it was your hairband, and you were all like, whatever. Hayseed. What's this, Rogue? Are you talking to me? You talking to me? Yeah, stretch bag. Any updates? I have not been able to see anything with Eastman. I didn't see the link. Didn't.
I'm watching it right now on my laptop. And let me see here. Oh.
He's still on the
Pressing
stand.
buttons. Well, no. Oh, they're taking a break.
Wow.
Oh,
Pooping is universal.
And we wonder why nobody's getting arrested.
Shit. Yeah. There you go. Because all these breaks.
You
That's
guys
why
need to fucking get to work. Just
Right?
like buckle down. You get a bottle, put it under the fucking desk, and
power through
power through it.
and use some mics.
You know,
I love the Mark Meadows news.
what's the Mark Meadows news?
All the money back from his publishers suing him for lying to them. So they want all their money back plus $1 million. I'm not kidding. That's real. Ron Filipowski reported it.
That is pretty
That's
funny.
crazy. He's so sad. His testimony was good. Should find it in preceding. Wait, Hayfie already went? What happened? Ours is Brondo Green.
what? Hafey should be next, right?
Well, I don't know. Did we miss Hayfie Oomph? Is that what you're saying?
We missed it? We'll go. It's recorded. Just go watch it. Let's watch it.
All right, hold on. But really? Okay. All right. Do they have a clip of it? Okay, wait. Let me go. Okay, let's do this, and then maybe they'll have the other. Here we go. Oh, here we go. Okay. Day 5, part 3. Oh, shit. Okay, well, we're watching this. We don't care about that guy anyway.
No, it doesn't have to be live. Just watch. Yeah, I want to watch this one.
There's some tweets from Tim Heafy, 4 of them in response to the interview that you guys sent the article over about, saying that, he's been taken out of context and Trump is responsible for everything.
Oh, what was that? Can we go back to
What?
that? Can we go back to what you just said to the other? What? This is the this is
That
the
was
live
like an off
recording.
mic, off cam, like
A
he
hot
didn't
mic, yeah.
Hot mic.
Yeah.
Hot
Hot
mic.
mic. Uh-oh.
Ugh. Nobody fart. There could be more cross, but he went direct and at least beginning of cross. Okay. Oh, is this a different? Oh, no, it's not. I don't know. Asked and answered. Yeah, this is from
Sorry, Art.
when I was gone. Good, they have captions now. Jeez.
And has Mr. Heafy been admitted? Great.
Wow, sure.
And there's just one preliminary issue, Your Honor, when you're set up.
Okay, spit it out. Don't make me put you on high speed. Mr. Hee
The
Hee.
computer.
I like that the captions are in the middle of the fucking screen. That's great. Thank you, C-SPAN.
So one preliminary matter. Congressman Buck testified yesterday as their witness on the January 6th committee and the report. We would move to strike then Congressman Neal's declaration from the record. Since we're not getting the opportunity to cross-examine him, they made the choice that they used Congressman Buck rather than Congressman Neal's. He had some things in his declaration that Mr. Buck or Congressman Buck did not testify about. I don't plan on asking Mr. Heafy to rebut what's in Mr. Neal's declaration, since it should be struck from the record.
What's Troy Nels, NEHLS? He was supposed to testify and he isn't.
Testimony for the January 6th and considered Mr. Neal's declaration. So I think to the extent Mr. Heafy has things he wants to say about that, he should go ahead and say them.
Okay.
But given that I conditionally admitted, you may decide that it's not necessary.
Okay.
But I can't kind of
There's not enough weed for this.
well, I can. That's what they say about bench trials, right? That you can forget what you saw. But I think
Which I don't even know what you're saying when you're captioned.
If Mr. Heafy has things to say about the Neal's declaration, he probably should.
I'm sorry, could you repeat that, Your Honor?
I think if Mr. Heafy has things he wants to say about well, first of all, why don't you tell me? Would you like me to consider when I make my final determination on the January 6th report, the Neal's declaration?
Yes, Your Honor, and we believe it's proper. You know, the court isn't necessary. The court is not required to only confine itself to testimony when determining the admissibility of a report.
Anybody
Obviously,
want
the
to
court's
use a
already
microphone? Anybody?
made consideration of it and viewed it, and so we think we've already relied on it, obviously, and it should stay in. And I'm guessing you'll put the same amount of weight on it as you have already. So, yes.
That may be my preference as well.
And I appreciate that, Your Honor. I'll just make the record that yesterday we were given the choice of door one or door two, Neal's declaration or Congressman Buck. And we had to choose Congressman Buck. And so I think, given that you've required us to make Mr. Heafy available for cross-examination, even though he had submitted a declaration and we were willing to stand on that, and that Congressman Buck has been made available for cross-examination, Congressman Neal's has not suffered the same fate. So we're happy if Your Honor wishes to consider it, but would just urge you to consider it for the weight it deserves.
And I agree, the country to here, but why don't you, if Mr. Heafy's ready to respond, why don't you do that in my final findings and fact conclusions of law, I will state one way or the other whether I considered Mr. Neal's declaration.
Thank you, Your Honor.
Yeah, they're getting
So would you like to
closer.
swear Mr. Heafy in?
Yeah, we make it so, change the view so we see he's a little clearer. Mr. Heafy, can you hear me? Yes. Okay, so I think that you're going to need to do something to get closer to the microphone because you're very faint.
Is this any better?
It's getting better.
God, what is wrong with people?
Any better? Not really.
No.
Not great.
Okay.
I apologize for the technology issue.
Where's my go ahead 10 seconds?
You're not the first, Mr. Heafy.
I just don't know where the microphone
Yeah, that's fine. And we'll let you know if we're having trouble hearing you, okay?
Okay, I I would speak up, Your Honor.
Oh my gosh. If this is not proof that like we need younger people to be running this country, I don't know what is.
I swear, yes.
Great, thank you.
Please introduce yourself to the court.
Like my daughter knows how to like turn down the screen brightness and on my phone and like I'm like, what? How do you what? Like
I previously served as the chief investigative counsel to the House of Representatives Select Committee to investigate January 6th attack on the U.S. Capitol.
So we'll get to the January 6th committee in a moment, but just want to go over your background a little bit. Where'd you go to college?
I went to the University of Virginia,
What degree did you get?
got a bachelor's degree as an English major. That was in 1986.
Did you go to law school?
He's as old as
I
me.
did.
Where'd you go to law school?
I came back for 2 years off. I came back to the UVA and graduated in January.
I didn't. I just started drinking.
What did you do after graduating from law school?
I was a law clerk to Judge John Terry on the District of Columbia Court of Appeals. And then I worked as an associate at Morrison and Forster Law Firm in San Francisco.
How long did you work at Morrison and Forster?
No.
For about 2 years until my wife graduated from
Uh-oh,
graduate school.
we lost
and then
Jim.
moved back across country to Washington, D.C.
What did you do when you went to Washington, D.C.?
I was an assistant United States attorney in the District of Columbia. Eric Holder was the U.S. attorney at the time who hired me.
What did you do while you were an assistant U.S. attorney in the District of Columbia?
I was there for almost 10 years, and I moved through various sections in the office, tried 65 jury trials. Ultimately, my last assignment was in a gang prosecution unit. I had
is he in like a hostage situation? Like,
Yeah.
what?
I think the camera's at top, and he's sitting on the floor in a
What
empty
did you do
room.
after leaving the U.S.
Joe!
Attorney's office in the
Not
District
really.
of Columbia?
Come on up, Joe.
I moved to Charlottesville, where I still live, to be the assistant U.S. attorney in Western District of Virginia. That was in 2003.
And what did you do when you were an assistant U.S. attorney there?
I love what I did in D.C.
Well, I didn't write torture memos with John Yoo, I could tell you that much.
Yeah, seriously.
After 3 years in the U.S. Attorney's office in Virginia, where
We're
did you go?
watching Heafy's testimony. There he is.
What type of work?
Sorry.
No worries. Did you do
I wonder if we can
investigations
do
as well?
this.
I did, yes.
There we go.
And how long were you at McGuire Woods?
Man, Jim.
I was there for over 3 years until I went back into government service in the Obama administration.
What was the government service that you went back into?
Deep state. Deep state. Deep state. Deep state. Sorry.
He really is. I mean, you know.
Well, no, I just heard Obama, and so, you know, if I were MAGA, I'd be triggered by it.
Yeah.
I served in that position as U.S. Attorney until the very end of 2014.
What were your duties as U.S. attorney?
He said duty. Jim is playing hard to get.
All of the criminal prosecutions and civil cases tried by the 30 of lawyers who represented the western part of Virginia.
You said you finished there in
Mr.
2014.
Isn't it beautiful, Lee?
What did you do after that?
I'm so lucky. I have the best friends in the world.
Practice to another based firm in Williams, where I was splitting time between Richmond and Washington, D.C. as the chair of the white collar defense investigations practice at Huntington Williams.
At some point, did you do some work for the city of Charlottesville?
Sir.
Oh, we lost you.
Yes, so, yes, I lived in Charlottesville, lived there this whole time, and in August 2017, there was a horrific public event in which there were protests and fatalities, and the city hired in Huntington Williams.
Yes.
Independent review of how my client
Jim is here.
prepared for and managed.
Right? Talk about a strike force.
And summer of similar nature.
Happily be their court jester anytime.
Was that event in August of 2017 the Unite the Right rally?
Yes, it was.
When did you become involved with the January 6th committee?
Not until forward. I believe in June or July of 2021, the House passed House Resolution 503, creating the select committee. Soon thereafter, there was an effort to put a staff together.
That's right. Charlottesville was a bunch of Nazis.
A dozen people hired.
Great documentary just came out on that.
What was your official position?
Is that the insurrection or something next door?
How did you get?
It's called No Accident.
No Accident. That's the one on HBO. I want to do a documentary night, you guys, and do like 2 documentaries and talk about them. I want to plan that for when. I would love to do that.
Me and Jim watched Dugan last night. Oh my gosh, don't watch it. It's so bad.
He's so terrible.
What were your responsibilities as chief investigative counsel?
Seriously, Jay.
National Staff backed up Chairman Thompson. I spoke to him and ultimately made hiring decisions, hiring his chief investigator.
Dude, turn your feed. Come on, your game's
So
up.
what I do is we're essentially to run a vision. First, hire a lot of people, lawyers, and other professionals to work with fact gathering. Then over the course of the duration of this subcommittee, I supervise the work day.
How many lawyers ultimately were there roughly on the investigative staff?
Yes, active measures definitely. I feel like everybody wants to see that again. Plus. And Jim's documentary, everything. A film festival, if you would.
How did you choose who would be on the investigative staff?
Investigative experience. Candidly, I was looking for people that had been investigators, that had interviewed witnesses, that had reviewed.
We chose by their deep state operative name in alphabetical order, sir.
Anyone who made the secret hand signal.
This Georgia document is awesome, by the way. If you haven't started.
Percentage
Oh,
for
really? What
individual
document?
U.S. Attorney's Office or DOJ,
From
roughly.
Coffee County, they released the
Oh my gosh.
investigative report. It's like
Oh, shit.
350 pages.
I haven't been home. That's fantastic.
Yeah, it's good times. Lots
Did
of
you
fun
tweet it,
names.
Jim?
Hmm?
Did you tweet anything about it that I can go
No,
look
yeah,
for?
no, I'm
You're still
about
reading. Okay.
10% through it. Yeah,
It's like 300 and some pages.
there's a lot of tomatli and all kinds of fun
Ooh.
shit.
How, if you know, did
Oh,
the
yeah.
investigative staff
Hey,
for the January
Bergie, I know
6th
you're
Select
listening.
Committee
We got to
differ
get
from
David Hancock
typical
back and find out what the fuck
congressional
is going on with him.
investigative staffs?
So, Bergie, get on that.
Because again, Congress really doesn't do these kinds of investigations very often, and therefore a lot of the lawyers from other congressional people. We have some investigations. The one different, my understanding, congressional investigation before, but my understanding is that the other thing different about our process was the involvement of our members, the members of the committee themselves were very involved in the day-to-day turning the wheels of the investigation. They participated in interviews. They had admitted sometimes daily reports on what we were learning. And I think that's different from the normal congressional process. Staff does most of the work, the fact gathering, and members are giving that information before the public receives.
But as you understand it, typically the investigative staff does not include seasoned investigators from the DOJ.
I don't believe that that is typical. That's right.
Now, what party affiliation are you?
What?
Was there any political litmus test for determining who would be on the investigative
Who's
staff?
asking this question? Is this the Trumpy people?
Absolutely not.
Yes, it is. He's on direct right now. Oh, he wasn't? Well, he knows how to do it, so I don't care.
Well, just focusing on people who you did know, were there
Figure it
Republicans on
out.
the staff?
Yeah. Yes, there were.
Can you give me
Winter
some
on
examples?
fire.
You should be objecting, my guy. Where's my crew guy? Come on.
There. Hi, Clark. Shiz hot as fuck for MAGA. Yeah, well, you know what? Fuck around, find out. It's real. They don't think it is, but it is.
Standing on another council,
If anyone's paying attention.
reporting to her directly, Mr. Kinzinger, our lawyer, I believe, was also Republican. So there are a handful that were, but again, that was
Let me make sure it's all the way.
my experience.
When did your team begin the actual
Oh,
investigation?
for fuck's sake, I'm sorry.
Right away, you know, we did follow along. We were approaching, we were going to aspire to end Congress, and just a lot to do. So almost immediately upon my arrival in August of 21, we were requesting documents. We were starting to talk to people. I think some of the first transcribed interviews in which I participated were in September of 2021. So very soon after this point.
What was how long did the investigation last?
It lasted up to 11:59 p.m. on January 3rd of this year, and we can be used kind of every possible minute to get things done. So it was about 16 or 17 months altogether.
Did you intentionally string out the investigation so that it corresponded with the
What?
midterm?
What the fuck kind of fucking question is that?
Oh, wait, is this the Trump lawyer? Wait a minute.
Of course it is. What other idiot would ask that question?
Very focused to move as fast as we could, and frankly, could have gone on for 16 months and had additional
I think so.
potentially relevant.
Now I don't know.
to try to find.
What was the
Was
final
there-
result of the investigation?
Was there
That's your-
another video? Is this part two?
No, I think this is direct.
Actual findings about the fact that
He's just he's just saying, did you do it? No, you didn't. Of course you didn't. You know what I'm saying?
I don't remember the exact date, but sometime in late December was issued.
He's getting ahead of the other side argument.
And that's kind of the official.
No. He is Trump's witness, though, guys.
Oh, he is? Oh, I'm so
Yes,
sorry.
it is.
I thought he was
Submitted declarations in this matter?
No. He was called by the Trump side in their case in chief.
Opening declaration
so
and your
sorry.
supplemental declaration?
Colorado.
So
Thank you. So sorry, you guys.
So who is asking the why doesn't it show who's asking the questions? Is this
Truthful and
the
accurate
screen?
to your knowledge?
See, that really does sound like your guy.
Your Honor, I'm not
Oh
going
my
to go
God.
over the declarations. You have them, and I know the intent of this
I'm
was
so sorry, you guys.
for
I should figure out
cross-examination,
who the fuck
but I do
that
have
is.
some questions for Mr. Hafey regarding rebuttal issues on some.
You would like me to consider the declarations that you submitted?
I'm
Yes.
very confused right now.
Just
Hold
to
on,
short
they're gonna-
circuit this rather than go into it at length since you've seen them. Now, there has been some suggestion by Congressman Neal's in his declaration.
Yeah.
Well, first of all, have you reviewed Congressman Neal's declaration in this case?
Yes, I have.
Now, he suggests that the January 6th report is somehow compromised by virtue of the fact that the committee
I'm
presented
confused.
Okay,
at the
here's the
hearings. Are you
thing.
familiar with
If
that
he is
allegation?
Trump's, then he is on cross because that is your guy.
Okay, but I know it is, but where's the direct?
No, that's probably in
What is your
part two.
response to the assertion that
Isn't
evidence?
that a different video?
It probably is. We just watched the wrong.
We
video.
should definitely watch that first,
Okay.
right? I
We can
mean,
do that.
There was a text message
Easy
that I believe that
Oh, the blue circle. But he was sworn in. Wait a minute.
incorrectly indicated that a particular sentence from a text.
Joe Dempsey, help me! I feel stupid. Oh,
Hold on.
I think we just let them do their thing. I think this is a witness that was called.
it's not live. It's not live though.
This is
No,
not-
this is part 3
Doctor evidence released. And there was also some allegation. that there
because
was,
he's still doing cross.
video or
Idiot
audio
guy.
that was doctored. Again, strongly dispute that there were some times where we used public proceedings.
Okay.
It's almost better if you don't know which side is asking the questions because you can really kind of listen to what they're saying and see what the answers are.
Right.
Yeah. I don't want to insult my boyfriend. You know.
I'm not convinced that this isn't.
I don't.
Okay, it doesn't matter. I'm not going to try. Yes.
Yeah. I mean, there's only one video of him, so.
Oh well. Let me make sure this didn't fuck up. Yeah.
Declaration.
Oh, it did fuck up. Okay.
Two allegations.
All right. Hold on.
That I received.
Those are the only two. Did you ever hear any allegation that other evidence was doctored somehow?
Oh, I really hate you guys right now. I'm just gonna say it.
No, I don't think so. I mean, those specifics I recall. No, I don't remember any other specific acquisition of doctor.
How many pieces of evidence were actually presented? And I don't need an exact number, but just ballpark during the 10 public hearings.
Thank you. We're back on the record and we continue.
So that is.
Oh, Joe Dempsey's got his spin on.
There's too much happening today.
Hundreds, thousands of the hearings were a subset of what we actually presented in the final report. So I think the report indicates exactly with more specificity than I can recall how many documents we were able to obtain, how many witnesses we interviewed, all of that is detailed, more specificity.
Now, there was a question raised yesterday about whether or not the January 6th committee had interviewed leadership from the Capitol Police. Did the January 6th committee interview leadership from the Capitol Police, including Chief Sund?
Oh God, I did it.
Yes, we interviewed 6 or 8 or 10 even senior officials of the Capitol Police, including Chief Sund.
Were there any interviews or depositions that were kept confidential and not released to the public?
Yeah, there were a handful of national security related witnesses, primarily people that work and some continue to work in sensitive positions inside the White House, that we agreed that we would not release the identity of those witnesses or the transcript, because public release would be debilitating to them individually and to the safety and security of the White House complex. So there were a handful, 3 or 4, I think, of those transcripts that we did not release for that reason.
Other than that small number of transcripts you did not release for national security purposes, were there any other interview transcripts or deposition transcripts that were not ultimately made public?
I don't believe so, no.
Now, do you recall that the committee took a deposition of a person named Kash Patel, former Chief of Staff to Acting Secretary of Defense Christopher Miller? Was his deposition transcript kept confidential somehow?
The motherfucker suing me for $10 million or attempting?
Right. This would be the
That
Chud.
fucking guy? The
Yeah.
chud with the
Is there
googly
any
eye,
effort
that
to keep the
motherfucker?
deposition transcript secret for a longer period of time?
No.
It looks like a Pokemon.
Was it the very last one released?
No, not. Again, there was no prior reason to the order which they were released all at the end. I don't remember when his was, we released them 10, 15, or 20, or 30 at a time over those last few days of the committee's existence. So I just don't know. But if your question was there an intentional effort to hold his investment?
Did Mr. Patel ever reach out to ask to provide testimony at a public hearing?
We never dealt with Mr. Patel directly. He was represented. I believe Rick Silver and Bush Blackwell was his lawyer. And I don't remember Mr. Silver ever making a request for Mr. Patel to testify in a public hearing.
Now, as an experienced investigator, why might an investigative team wait to release transcripts to the public until the end of an investigation?
Any kind of investigation is hampered if you're unable to discern what a witness is providing from personal knowledge versus things the witness may have heard from other sources. So it's very important to try to prevent public release or sharing in any way during the investigation. You're to sort of ensure that you're getting personal knowledge. So we didn't release either publicly or to witnesses what other witnesses said, even who other witnesses were, because we wanted to ensure that what we were getting from each witness was a product of observer memory, not something that they read in a transcript or saw in the news report.
And is that,
pretty standard? That was not a unique practice. It's like, that's the way I've always done it.
Maybe.
now,
Secret.
did the
Sounds
Department of
good.
Defense
We have
produce
quite a
documents
list,
to the
so
January 6th
definitely.
committee?
Yes, a lot. In fact, it's a lot of agencies did, but defense included.
Did the Department of Defense refuse to produce or withhold documents, relevant documents that have been requested by the committee?
Bye, Steve. Oh, have a good weekend.
Would the request for documents that the January 6th committee sent to the Department of Defense have covered documents, if they existed, showing that President Trump had authorized 10 to 20,000 National Guard troops to be on the ready?
Objection, Your Honor.
What's the objection?
Your Honor, my understanding.
What's the object? I don't want to know the answers. The objection.
And secondly, it's beyond the scope of our understanding of what this witness here was.
Really?
Describe the processes of the January.
I think you opened it up when Patel opened his big fat fucking mouth.
Earlier witnesses for.
Spent like the fucking day on processes of the J6 committee.
Exactly.
What are you talking about? Whiny bitch.
Okay, see ya.
Had known that his testimony would be used as substitute.
Well, yesterday they advised the court that they were going to call him as a rebuttal specifically to the testimony of Mr. Patel and Ms. Pearson. And so his testimony certainly isn't a surprise to me. And I don't think the question is speculative. Mr. Patel testified that there were documents showing this authorization.
Yeah, he lied. Exactly right.
Because he's a lying, perjuring sack of googly-eyed shit.
I know. I was screaming this during his thing. I was like, dude, why would you say that? You're so dumb. Don't say that. You know that's not true.
So let me repeat the question.
He'll come back.
Would the document
Don't
requests
worry,
that were sent to the Department of Defense been broad enough to cover any documents that the Department of Defense had showing records of an authorization by the president for 10 to 20,000 National Guard troops to be on the ready?
Absolutely, and there was no such document produced.
Now, did you attend Mr. Patel's deposition?
I did.
Did you investigate the many assertions made by Mr. Patel in that deposition?
We asked him about conversations that other witnesses had related to us that they had.
Right now he's pooping his leather pants.
As you know, every investigation attempt to corroborate assertions. So yes, we plugged in the questions, the answers, Mr. Patel into the evolving body of work of the select committee.
Were you able to observe Mr. Patel's demeanor during the deposition?
Was he or was he not a chud?
Based on your investigation, including
Would
the
you call
deposition of
him
Mr. Patel,
chud?
do you have an opinion?
Would
as
you
to-
consider him a credible witness?
That's right.
Read my mind.
Does cannibal humanoid underground dweller come to mind when you see Cash Patel?
Do you kind of grab your package just a little bit when he comes in? I don't know.
Your Honor,
Wait, what's his answer? Oh, did they object?
allows for extrinsic testimony
Yeah, they
by individuals about a witness, and specifically allows them to provide an opinion as to that witness's character for truthfulness or untruthfulness. Mr. Hafey has a basis for doing so, and he is allowed to do so. I'm certainly willing to provide the court with legal authority. If the court would like briefing on this, I think that would be fine, and we could take the testimony and then just decide afterwards whether it be stricken. But this is squarely within the confines of Rule 608A.
That calls for a real bull. with
He did his homework. That's called doing your homework, kid.
A sexy. I love.
Are we playing big boy? Are we playing big boy law now? Okay.
That's right.
Hey, can I read you something that comes from that report while she's doing this?
Please.
Okay. So it's pretty cool. It's just briefly. It says, according to Marilyn Marks from the Coalition for Good Governance, there were multiple tiers of individuals involved in the Coffee County computer trespass incident. At the top tier would be Rudy Giuliani, Sidney Powell, Mike Flynn, and Jesse Banal.
Oops.
Uh-oh.
Mr. Hayfie, did your team
Gosh,
investigate
it's really
the
going to be
claim
hard
that
to
the
follow
president had
through with those
authorized 10
suits
to
from
20,000
fucking
National Guard
prison?
troops to be on the
Cash. Mike.
Jesse,
Way, Joe Flynn. You can
the
suck my
fucking lawyer. The lawyer
the lawyer.
is in the top tier.
The
What's
lawyer.
suing me?
Oh my god. Judge me
Did
by
you
my
see-
enemies.
Your Honor, we would object to that as hearsay and ask that you strike it.
Ask Clayburgh about Marilyn Marks, who her bestie is.
The investigation, I was asking
Hey.
precisely what you had said. I could
Who is
ask.
it? Don't leave me in suspense.
The
Please use
report
it.
is hearsay. The comment, any information in the report about those statements is hearsay. The witness's statement is, statement witnesses testifying to is hearsay. It's intended to prove the truth of the matter asserted. It's not a court statement. We have to be the power and have the time to talk to former Secretary of Defense Department House, or I'm sorry, Chief of Staff Department House. But I'll check that out. I'll get the right.
PO 13848 isn't fucking hearsay.
I've already accepted the finding that they could find no evidence, including from Mr. Miller, about the $10,000 to $20,000 troops. So I'm going to sustain the objection that the testimony is cumulative.
No further questions on direct, Your Honor.
Right. Good point, Ted. What are your interests or hobbies?
Wait, did they rest their case in chief? I'm so confused.
I think he said no more questions on direct.
Well, I know, but isn't he the crew guy and this is Trump's guy now? So this is a cross?
This
So
is
that would mean they're using Hasty as a rebuttal witness. So that means the defense rested their case in chief after Doofy Doofus.
Well, that's quite a mic drop.
Thank you,
I
Aaron.
might have saved Cash Patel for the end.
Good afternoon, Mr. Hafey. Is it, and I apologize, do you pronounce your name Hafey or Heafy? I've heard it both ways.
Yeah, it's Hayfie with the long A.
Okay, thank you very much. So let me ask you a little bit about your experience.
So, this report.
So, do you have experience running large investigations?
Yes, was U.S. Attorney.
Oh, coming out swinging, huh, bro? Whoa. Hard hitting.
Investigation was substantial and actually similar. So yes, before taking this position, I had supervised other investigations.
Okay. And were those investigations, would it be fair to say they were grand jury investigations? Mostly? Okay. Did you supervise large grand jury investigations?
Objection, relevance? I mean,
Okay. So I think in your declaration, you had talked a little bit about sort of the number of documents and number of witnesses that the select committee called. Do you recall that? Okay.
oh my God.
Talked about
What a fucking genius.
witnesses, a million or so documents, those
You
types
always
of
think
numbers,
their
correct?
arguments are going to be slightly more sophisticated, and then they come in.
And do you have experience, for example, in grand juries, in investigations of that size?
Ask
There
and
really
answer.
isn't a there there.
I've ever had a grand jury investigation that had quite that many witnesses. probably a new in terms of volume of information.
Would it be fair to say, did you work in grand jury investigations with over 100 witnesses?
Yes.
Objection, relevance.
Really?
And would it be fair to say that you worked in grand jury investigations of over 100,000 documents?
Oh my God.
Definitely.
Dude, what is the point of this?
And would you?
What
agree-
is the point of this?
I guess, would you
Did
agree
they
that those are
think about
substantial numbers of documents and witnesses?
I mean, it's all relative, but yes.
Oh.
In the hundreds of thousands, I would agree with you that that's substantial.
Okay. And did any of those investigations result in indictments?
None of them, because fucking what? What?
And after
Man.
that indictment, you take that case to court, I assume, correct?
Oh my God, bro. Come on.
When I say you, I speak in collective, your office.
Collective. Yeah, just, you know, because I know what I'm talking about and everything.
And did you ever go to
Officer of that office?
the judge and say, Judge, we have a lot of witnesses, well over 100 witnesses, and we have over 100,000 documents. And so therefore you should accept these as true for,
Oh my God.
and you need not
No,
accept
it wasn't
them
a crew
for a
that did it.
conclusion of guilt.
Real people did it.
My Lord. You know what? Hey, Mr. Idiot McFuckface, okay? Why don't you go watch the Georgia proceedings? Because they have over 150 witnesses they intend to put on with at what once was 19 defendants and like terabytes worth of evidence. So yeah, it can be done. Shut up and sit down if you don't know how.
Allow for what you're suggesting.
Right. And part of the reason for that is because that evidence would be subjected to the adversarial process. Would you agree with me on that?
Oh, it's gonna be shithead.
Yes.
Don't
It
fucking
but it
worry,
already.
Take the evidence as hard as
bitch.
a court doesn't take the evidence, despite how hard a
God, I could
prosecution
never be a
office may
lawyer.
work
I would
on it,
be,
simply
like,
at face
bitch
value,
slapping
but
people
requires
right
it all
and
to be
left.
subjected to the adversarial process, correct?
In criminal case, for a defendant to be convicted, that the high standard of proof than that which applies in a grand jury. Grand jury's probable cause, guilt in criminal cases, guilt beyond reasonable doubt, and that's a higher standard.
But for a court to make that determination from a procedural standpoint, it has to subject that evidence to the adversarial process, correct?
No. What is what are you talking about? You're confusing the constitutional conversation you had with your dum-dum witness about committees and shit and having Republicans and Democrats on them
No, you
with
talked
the criminal like the criminal rules of procedure, you
members,
fuckwad.
the members of the select committee, their involvement in the committee's activities, correct?
Great question, dummy. Great.
Okay.
What did you just say? What do you
and-
even just say?
And then how it differs from your understanding of the normal process, correct?
Yeah, anecdotally.
What is normal process of what, dude?
The investigative process that they typically are in other congressional committees.
Okay. And it sounds like, and I'm asking you to repeat some of your testimony, but I just want to make sure I'm clear. So you talked, for example, about Mr. John Woods as a member of the investigatory staff, correct?
He was the co-leader of one of our 5 investigative
Okay.
teams.
And would it surprise you to learn that Mr. Woods
Very much involved.
And you received his name through a reference from Representative Cheney. How did that work?
hit the like, share the broadcast? Thank you all for coming back.
He as a potential staffer and asked me to speak with him, and when I did and got to see his qualifications, we hired him to co-lead the whole team. And we also had collaborated with the council's chief.
And Representative Kinzinger also recommended an attorney hire, correct?
I think with Mr. Kinzinger, his lawyer was already on the staff, and Kinzinger asked that he be sort of designated as his collaborator to be counsel to Mr. Kinzinger. He was a lawyer that came to us from Central Intelligence Agency, received by.
And so did he represent Representative Kinzinger in the, did he have an attorney-client relationship with Representative Kinzinger at the same time he was a staff member on the committee?
What?
Objection. Why would he know?
Your beeswax.
Like,
Mr. Kinzier's counsel said he had separate conversations with Mr. Kinzier, which I was not part of.
Okay.
hey, sir, aren't you a lawyer? Do you not have more than one client at a time? Like, is that not
And
allowed?
you
I
said
mean,
normally, and I'm just trying to
Ted,
get a sense of the extent of your
literally
knowledge.
no maggot
You said
is watching this
normally
case.
congressional committees don't include
Zero
Cut it up and
maggots.
put it on the news, though. They'll get it in front of them.
investigators of the type
What'd
that
you say, Joe?
They'll get it in front of them.
or
Ted's
hired on
completely
the
right, I
committee.
think.
Correct?
This is about narrative.
Got it.
This is like filler for other things to talk about other than everything else people need to know.
Right.
Being hired on the select committee is atypical for professional staff lawyers, policy people and experts on policy, whereas I was looking more for investigative experience. And there are people in government who work in Congress with investigative experience, but not as much as in the Department of Justice.
Okay. Now, I think you're in your declaration, you talked a little bit about the members and the purpose of the committee. What was the purpose of the committee?
The facts and circumstances that inform the insurrection, the attack on the Capitol, and to make recommendations to try to still motivate changes in law that would make similar attacks in the future less likely.
And the members themselves, is it your belief that they went into the committee with an open mind as to the
oh my God, objection, calls for speculation. Like, what the fuck are you talking? Did you give them a rose, Mr. Heafy? Were they there for the right reasons?
In terms of the overall findings, yes, they were.
How many were Republicans?
Where in fact would lead the investigation.
Mr. Heafy, at what point in the investigation did hometown dates occur?
President Trump engaged in an insurrection?
Yes.
Okay. So was Representative Benny Thompson, was he the chair, am I correct, of the committee, or a co-chair?
Yes.
Do you not know? Because if you don't know, you should probably quit.
I'd like to show you what's Exhibit 1084.
Your Honor, I believe these are going to be tweets that were sent by members of the committee at some point after January 6th. We would object that Mr. Haley does not have personal knowledge of these, they have not been authenticated. But in any event, if the insinuation is that somehow
Crazy Ivan.
the committee had agreed to see those.
Hold on, I want to hear what he said.
We would like the opportunity to read back.
Can you put the thingy down so I can see the okay, sorry.
Yeah. Oh, come on.
Ah, damn it. I really wanted to know what the objection was.
Sorry. I can run it back.
Objection is overruled to the extent it's objecting to the tweets.
Okay. Thank you, Your Honor.
It was overruled.
Could you show Exhibit 1084, please? Oh, boy. I can't even read that myself. Can I use
I
your
can.
computer? Okay.
Why can't you? Would you say that Benny Thompson is all in his feels about this?
Let me see right here. We're just having some technological fumbling on my part.
No, you're having
Could you see this,
brain and eyeball problems, sir.
You're having a lack of argument problem.
and you see that was sent by Representative Benny Thompson.
Yeah, what's the timestamp on that? Because it just says January 6th.
Okay. And you see where he tweeted, Trump fed this vile monster. I'm sorry, said fed this monster with his vile and dangerous talk. Do you see that?
Yeah.
Okay. Is your view that statement is consistent with going into the January 6th committee with a fair and open mind?
Oh my God, you're so dumb. That's a dumb question. That's so
Benny
stupid.
Thompson was the chair of the Department of Homeland Security Committee. Well, he had oversight over Department of Homeland Security, so he knew going in.
Right.
Was uncertain, and that was the task of the committee. So yes, I don't consider that statement to be one reflecting the closed mind at all.
And if I remember correctly, the committee, one of the things that the committee concluded was that President Trump himself was responsible
Because he was.
for the violence that occurred on January 6th. Is that correct?
President Trump and others, but conspirators, yes.
Okay. And so I'd like you to, we scroll down a little bit. I'd like you to look at that second tweet where it says, the events of today, referring to January 6th, are the inevitable result of the tyrannical and idiotic leadership of Donald Trump.
Oh my God. If your own attorney that says that stuff out loud, I don't care how.
Into these investigation with a fair and open mind.
Siegfried checked Magaport.
Well, it's a political investigation. So what is your expectation of fair and open-minded? I mean, come on.
I would just say, I don't know what was in the mind of Benny Thompson. Not in his head.
So, yes, I would consider Chairman Thompson to be open-minded throughout the course of the investigation.
Okay, could we go to Exhibit 1085?
Well,
please?
let me show you this.
Let me show you when he said bad things about my client.
Can you see where we searched Trump in all of Benny Johnson's tweets?
And you see that first tweet where it says, former President Trump has to be held accountable for his actions that precipitated the riot at the U.S. Capitol on January 6th. Do you see that?
It's a good point, Siegfried.
And is,
How
in your view,
dare he?
with someone going into this investigation with an open mind?
He just said he answered that. Asked and answered.
Okay.
$7. No.
Sir, all you're doing is just reiterating that other people agree that your client is responsible. Like, what are you doing?
Attack on our nation's capital. Do you see where it says that? And you say that when Representative Thompson said that
This is the third time he's
President Trump threatened our democracy by instigating, that he instigated the attack, that he's entering into the
is this supposed to be gotchas?
with an open mind.
Because I don't feel very gotcha.
relevant to the judge.
He's certainly open-minded about the scope of the investigation. I think that fact obvious on January 6th.
That Donald Trump I'm sorry, I apologize. Go ahead.
Yeah, let the witness talk, dumb fuck.
Starting an investigation with certain things you know and certain things you don't know. The fact that President Trump instigated the attack, it's not just January 6th, those words during the speech on your list. We were plugging those facts into people who motivated them, how people reacted to them.
I don't know. These closed captioning, they're bad. Just so you know.
Yeah.
Certain facts are sort of obvious at the beginning of the investigation. It doesn't mean the investigation has reached a conclusion or is closed-minded.
People are professional and they follow their investigation even though they have a feeling.
Well, you don't open investigation without probable cause. So, like, this is the thing. Like, there's probable cause to believe that Trump incited the mob. And then you investigate to see if you can prove that beyond a reasonable doubt or by a preponderance of the evidence. That's how it works.
In his investigative approach for January 6th.
Oh my God, that's the fourth time you've asked the same question.
He was throughout the entire investigation.
Okay.
I would just say, Dave, the answer isn't going to change.
You see where Representative Thompson in his tweet included this sort of block statement that says he
called
summoned
a meme, douchebag,
and he lit the flame of the attack. Do you see that?
Well, then I guess your guy.
He's it.
He's
view. I'm
tweeted.
assuming that is fully consistent with him being fair and impartial with respect to investigating President Trump's
That's the fifth time.
culpability, non-culpability for the events of January 6th.
Question.
So dumb.
Fucking
culpability or non-culpability of any one person. We were investigating the facts and circumstances that informed.
Right.
Certain things were obvious at the beginning, other things were not. So in terms of his overall approach to the investigation, to fill out all of the relevant facts and circumstances, I don't believe it was in any way biased or preconceived.
So you said there were certain facts that were obvious in the obvious at the start of the investigation. And
yeah.
Even I just want to make sure I'm correct that one of the facts that was obvious at the start of the investigation was that Donald Trump instigated the violence. Is that correct?
Donald Trump talked about violence directly, yes, during his speech in the left.
So is that a yes to my question?
I'm sorry, repeat the question.
Could the court reporter please repeat the question?
You don't know your own question?
I wasn't listening. That's what I said.
So you said there were certain facts that were obvious at the start of the investigation. And I believe, I just want to make sure I'm correct, that one of the facts that was obvious at the start of the investigation was that Donald Trump instigated the violence. Is that correct?
I'm sorry, I can barely hear those.
Yeah, I can read it. I'm going to read it because you can't hear the court reporter because she doesn't have a microphone.
Oh, yeah.
So the question,
Well, whisper judge, I'm not sure it's much stronger.
Does anyone have a microphone?
and I believe, and I just want to make sure I'm correct, that one of the facts that was obvious at the start of the investigation was that Donald Trump instigated the violence. Is that correct?
Yes, Donald Trump said we have to fight like hell, we don't have a country anymore. Right? That was something that was stated at the lips, which did in fact instigate violence. So yes, the answer to that question, yes.
Okay, let's go to Exhibit 1086. Was Representative Lofgren, Zoe Lofgren, a member of the commission?
Dude, yeah, crew boy, you need to freaking object to this shit. He cannot speak to the mental, like, or the personal thoughts of other people on the committee. He should have called them as witnesses if he wanted to ask.
1086. And in that, are you able to see that? Okay, and I ask you that because at the moment I can't see you, but we'll continue from the video. I can certainly hear you. And she says in the last sentence of that tweet, Trump incited this and he's a threat to the security of our country.
Well, she called it.
So is it your testimony that statement is consistent with being fair and impartial in the investigation?
Bro, listen, let me explain something to you. You're trying to defend your politician client by saying they have a First Amendment right while attacking other politicians for their First Amendment right.
I love Zoe Lofgren. She's fucking amazing.
And this, it looks like at the top is a official press statement from Ms. Lofgren. And in it, she says
January 10th.
that, can you scroll down just a little bit?
It would be with no joy. So how about that?
Excuse me one moment, Mr. Hafey.
Yeah, people generally do statements when they're fucking elected officials. It's how they keep their
She
constituents
says,
informed.
if you see that paragraph that begins in italicized font,
I know your dude
towards
just
the
sends out
towards the bottom
middle
of
of the
it.
night.
Today we don't need a long
truth.
investigation to know the president incited right-wing terrorists
Right, speech and debate
to
clause,
attack
anyone? Thank you,
the Congress to try to overturn constitutional government. And it's your view that that statement is consistent with Ms. Lofgren being fair and impartial on the committee. Is that correct?
It's fair and consistent with the facts of what happened.
Yeah.
This is sort of hypothesis based on observations at that point that it certainly informed the investigation. But I don't consider them to represent a closed mind about those facts and circumstances.
Had they uncovered evidence that showed Donald Trump was in fact not responsible, they would have concluded that.
Yeah. It's how grown-ups work. I understand that's not how his grown-ups work.
That's what happens in investigation.
Okay.
Yeah, that's how investigations go, bro.
We'll go through them quickly.
Oh,
I'll
I
ask you,
bet you will.
assume you'll
The
give me
same
some,
questions.
and we'll try to move this.
You provided these to me earlier today, I've seen them all, and yes, we'll have the same answer to all.
Why isn't the dude objecting? This is like nonsense.
So let's do this. Since we personally, on our side, didn't provide them, I'm just going to go to the exhibits. I'm going to say, is that one of the exhibits that you saw?
Oh my God.
To which you will provide the same answer if I read parts of the exhibit. Can we do that?
Right. Crazy.
No.
Eyes were fair and impartial when I was watching it live on January 6th.
So if you want me to hear the impeachment here, and unfortunately I have to walk through it.
Let's walk right through it then. Let's go to exhibit 1088, please.
Thank you.
Well, I guess it is. It's impeaching because he says that everybody was fair and open to any possibilities of where the investigation could lead. And Mr. Kessler is saying, no, they weren't. I think that's proper impeachment.
So do you see this exhibit here?
Does the judge get paid by the hour?
So it says, while we were performing our duties, the President of the United States, in an unconscionable act of sedition and insurrection, incited a violent mob to attack the Capitol. See where it says that? And that, in your view, that is consistent with someone?
Stop asking him if he sees where it says that.
I think that was facetious. I thought the 6:25 minutes he observed, but it does not reflect him or others that have the first line.
Okay. Let's go to exhibit 1095, please.
I want to skip to redirect.
Is he going to go through every member?
Oh, yes, he is. Because he doesn't have anything else to present.
Isn't that an actual?
Because he has no case. What are you looking for? What are you guys looking for, guys? Come on. Come on. Get with the program. Let's go, go, go. Next one. I think we're going to run through them. Don't have them all teed up, I guess.
At the end of the first paragraph, it says, Aguilar spoke on the House floor to call on his Republican colleagues to uphold their oaths of office by holding the president accountable.
This is so funny.
So here's where Representative Aguilar is asking others to hold the president accountable and support impeachment.
He's addressing.
And then later in the next paragraph, it says, when the president sent a mob to the Capitol, radicalized by his lies about the result of a free and fair election to stop the counting of the electoral votes, he made it clear that he poses a grave threat to our democracy. In your view, that's also consistent with Representative Aguilar being fair and impartial in the investigation in January 6th.
Dude, this is a Wendy's.
What?
Like, what?
The president, based on the same facts that were issued in our investigation, all 9 members that they voted, they should be impeached. And that proceeding took place before the meeting started. So, yes, they have made some preliminary determinations, hypotheses based on what they saw. But, again, wanted us to plug that in to protect us against all the evidence that we were finding. So I don't believe Aguilar and the others had made any conclusion other than that preliminary and one informed impeachment vote.
Okay. You see where it says Representative Stephan.
I hate this guy like a lot. I'm genuinely like grumpy about this.
Okay. And here she says the president incited a violent insurrection against our democracy. Proof he's unable to uphold the Constitution. Is that statement consistent with her being fair and impartial in this investigation?
Oh, these are apples and oranges. I don't like. This isn't even.
I don't think the judge is buying it.
She let him continue.
I think
Whisper judge was just like, she should have said, "This is how can he testify to somebody else's state of mind?"
So this says that the 9 impeachment managers will present. This is the second to the last paragraph. The 9 impeachment managers appointed by the House of Representatives will present overwhelming evidence of the facts of former President Trump's incitement of the violent insurrection that took place in and around the Capitol on January 6th, 2021.
Have you met everybody involved with this?
Is that statement consistent with Representative Raskin's?
That doesn't make any sense what you're saying, bro. Like, it really does. You're not making sense.
Yes, they let the impeachment proceedings, the chief prosecutor, if you will. But I don't think that they can close-minded about the overall factual circumstances that you brought to those actions.
Okay, so even though he said there was overwhelming evidence, and even though he said there was overwhelming evidence that President Trump had incited violent insurrection, and even though he actually led the prosecution of President Trump, you're saying that he remained fair and impartial in determining the conclusion in investigating and coming up with conclusions on the January 6th Select Committee. Is that correct?
Yes.
Because the goal of the January 6th Committee was not about the culpability of any one person. It was about the overall facts and circumstances that informed the attack. All the various components of it. The president's incitement of violent insurrection was one among hundreds of facts and circumstances that were considered. And even that, if there had been contrary evidence, we would have presented that. So I don't
and has led to 91 blah.
Represent that any of our members were, to use your term, closed-minded when we approached the investigation.
I'll represent to you that I've not used closed-minded, but I'm not going to object to your characterization. Let's go to the next. Let's go.
Yes, you have, actually.
So here it says, this is a remark from, I'll represent to you that this is a remark from Representative Luria. Did Representative Luria serve on the commission? I'm sorry, on the committee?
Yes, the commission.
No more.
Okay. And here it says that encouraged and emboldened by President Trump. You agree with me that that statement indicates that President Trump encouraged and emboldened people? That that's the meaning of that phrase?
Oh my God, what is your question now?
Okay. And it's your belief that that statement is consistent with the investigation, with a fair and impartial investigation by the January 6th committee. Is that correct?
Yes.
Okay. Let's go to Exhibit 1105, please. And this looks like an official statement from Representative Cheney. Is that correct?
Oh my God, stop asking. Oh my God,
And
please
did Representative
stop doing
Cheney
that.
serve on the select committee?
To the vice chair of the select committee.
Okay. And scroll up just a little bit.
It's already up.
Okay. Yeah. I'm sorry, scroll down. So do you see?
Oh Lord Almighty.
The president of the United States summoned this mob, assembled the mob, and lit the flame of this attack. Everything that followed was his doing. None of this would have happened without the president. Do you see where it says that?
Yeah. True or false? True.
And is that statement consistent
Waiting for the lie.
with Representative Cheney approaching the workings of the select committee in a fair
Oh my
and
God. Can you just make your question consistent? Like, shut the fuck up.
apologize.
Oh my God.
I mean, all of them were fair and impartial throughout the process.
There's no apology needed. Although I appreciate that. Let's look at Exhibit 1106, please.
Mm-hmm.
And this looks like an official statement from Representative Kinzinger. Is that correct?
Okay, so great. There's 9 of these, right?
Okay. And if you look at the second, the third paragraph, final paragraph, I'll say, where it says, "There is no doubt in my mind that the President of the United States broke his oath of office and incited this insurrection." See where it says that?
Yes.
He
Okay.
fucking sees
And,
where it says that. Oh my God.
Is that statement?
It doesn't have to be a two-point question every time, bro. Just pull it up and say, "Is this fair and impartial?" And he's gonna say, "Yeah," because this is dumb line of questioning.
I think all of these statements that you're showing me were put forth at the time of the impeachment. And they were declared completely unimpeached.
I kind of like that he's answering fulsomely every time.
Yeah, I know. I thought about saying, like, just make one blanket statement and then say same answer, but this is fine. This is better. He knows that they use them for clips. That's why.
Yeah. Welcome back, everyone. Max, welcome back. So
let's talk about that impeachment proceeding for a second. So the impeachment proceeding,
January 6th investigative team.
Is it your understanding that the articles of impeachment were whether or not President Trump had engaged in an insurrection? Is that correct?
No, I was not involved in that. I don't remember the allegations in the articles. Generally, my belief it was unfit for service, but I just don't recall the specific articles of impeachment.
Okay. Okay, I'm going to represent to you, for purposes of my question, that in fact it did include a vote on whether or not President Trump incited an insurrection. And you said that all members of the commission had voted yes on the impeachment question. Is that correct?
I believe that's right, yes.
Okay. Do you know how many? Do you know roughly what the vote was overall?
I don't.
Okay.
He's the lead investigator on the committee. He's not a member of Congress.
That didn't have anything to do with the
Okay. I'm going to represent to you that there were 232 votes in favor of impeachment, which constituted 54% of the voting members. And I'm going to represent to you that 197 members voted no, which constituted 46%.
So less.
What percentage, just to be sure again, what percentage of the members of the Select Commission?
Oh my God. Is it a math quiz?
Impeachment.
Is it a math quiz now?
I don't believe any of our members previously voted no. I believe all of them were in that 4% majority of the
Okay. So would you agree with me then that with respect to the perspective that President Trump cited in insurrection, that 46% of the members of Congress, their points of view were not represented on the committee?
What? No.
What? Oh my Lord! Were you somebody who
report?
This dumb must have filed an affidavit somewhere for Rudy, I think.
Yeah.
Okay. Now, did the committee have any any staff that was controlled by a minority opinion? Let me back up a little bit. Is it your understanding?
Yeah, ask a question that makes sense, dummy.
Committees normally have a majority staff and a minority staff.
We did. Kinzinger's and Cheney's. What?
And your commission did, and your procedures for the select committee did not have a separate minority staff. Is that correct?
Oh my Lord Almighty! Oh my God! Not everything has to be like.
Okay.
Didn't we settle this yesterday?
He just as easily could have said there was no majority staff.
Were there any,
Right, Joe, right.
you know of any other commission committee, and I understand the limitations of your testimony earlier, but are you aware of any other committee in congressional history or modern
Yes, I'm
congressional?
going to ask you a question that you really aren't, you know, here to
staff?
testify to anyway.
The Warren Commission, let's go.
Okay. Okay.
Again, if there is a consensus of the facts and the evidence, there is no need for a minority report.
Let's
Boom.
one moment, please.
Gosh, I guess it walked like a duck, huh? Jesus. Any bombshells, Joe?
Excuse me, just one moment, please, Your Honor.
No bombshells, but
The professor is done talking, so.
Eastman's going to come up for a couple more questions, and I think that's it.
That's it. And then they get their 15 minutes of closing.
Yeah, I mean, they burned a lot of the closing argument time, I'm sure.
Oh, all of it. Almost all of it, asking the dumbest fucking questions. Those attorneys were terrible too.
They were. So were the ones in the Kerry Lake trial. I mean, listen, folks, it's not a deep bench.
Do you see that?
They brought in new documents and
Okay.
yesterday.
What?
Let's go to the third page. Take the third page.
They put together a chart to show that professor that was just on.
Uh-huh.
The judge said, "Well, who made this for you?" And they were like, "Heather Honey made them for
The
us."
paragraph.
Oh, the
that
person they were
begins with,
denied that
there was
Heather
a lot
Honey,
of advanced intelligence about law
the one
enforcement.
whose testimony
Do you see
wasn't
that?
admitted.
And that's a quote. And I believe the article quotes you. Did you make that statement?
What?
Okay. And you say there was a lot of intel in advance that was pretty specific, and it was enough in our view for law enforcement to have done a better job, correct? Okay. Okay. And that advanced intelligence was about the potential for violence at the Capitol, is that correct?
Yes.
Okay. And now when you say advanced intelligence, did you mean intelligence or intelligence reports appearing before January 6th?
Yes.
Okay. Do you remember how far in advance, by any chance? I mean, did the spectrum of advanced knowledge? Do you have any memory? I'm trying to get a sense. Was it 1 hour before the start of January 6th? Was it 2 years before the start of January 6th? Can you provide a time frame there?
I can tie it very specifically to a tweet from President Trump on December 19th, where he made the very first reference to January 6th. He encouraged people to come to the Capitol and said, big protests in D.C., they are willingly violent. Immediately thereafter, that the intelligence started showing that to comment on the potential for violence. That was the spark, really, that ultimately erupted in violence on January 6th.
Okay. And so you started receiving lots of intel after that tweet, correct?
Heather Honey was the name I used at the
Or various law enforcement agencies received that intel after that tweet.
That's a good one.
Yes.
Okay. Okay.
Uh-oh.
And let's go to the ninth page. Okay. You see,
Party's over. Did the advanced intelligence include reports of plea plans and pre-reports of plea plans and pre-reports of plea plans?
Okay.
And how are the reports?
You see where it
prepared?
says one of the tips entered in Guardian on December 27th came from a person who was reading traffic on a website called the Donald.win, a hive of January 6th rhetoric. Do you see that? Okay. What was Guardian?
Guardian is a draft system which submit information into the central database. They're called Guardians, the tips themselves are called Guardians. And the FBI, I believe, received 55 Guardians that were all placed under that certain press umbrella. And I believe that this piece from the Donald that's quoted in this article is one such Guardian.
Okay, and that says below that, it says they think that they will have a large enough group to march into DC armed and will outnumber the police so they can't be stopped, the tipster wrote. They believe that since the election was stolen, that it's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is to literally kill people. Please take this tip seriously and investigate further. Was that one of the pieces of evidence, or one of the, was that the tip that was entered into Guardian on December 27th?
That was one of many tips that were introduced to the Guardian system. I don't recall this, but I know that sounds consistent with the kind of information
Okay. Did you or the committee form an
I'm going to
opinion?
represent to you all that John Eastman is basically in like a little
in advance of
battle
January 6th?
with the O2, C2, or whatever it is, and it's pretty much way better than this.
Oh. Oh. Please, I think for our personal use only, somebody should be recording at least part of it. So.
I am.
Yeah, just for personal. I'm busy breaking the heart of this judge.
Now, let me ask you this.
Hi, Jumbo.
This article also says, and I'm looking for the quote, but I'll simply ask you, that the final commission reports downplayed the failures of law enforcement agencies to fully prepare for January 6th. Do you agree with that conclusion in the article?
No, we published every interview that the law enforcement notified. There were several reports about detailed law enforcement
Okay.
I'll say the report together the whole facts and circumstances. That is not context, but it took nothing away from the constant cause of the event. President Trump citing the law.
They can't arrest someone without a reason. That's not legal.
Causation of the attack was President of the States and the whole conspiracy to disrupt the power of the
Okay. And that causation was one of the obvious facts that members of the commission and yourself concluded had occurred even before the January 6th Select Committee began its investigations, correct?
I guess I would call it more of a policy story. It was what they already decided to we were continually testing our evidence against that. It did not change. We ultimately reinforced that.
So let me ask you this, and we obviously this transcript will be used as part of
He's been
proposed
given an
findings of
interview
fact and
over
conclusions of
summer,
law
which
and
he
used
said
by
the
the
state
judge.
bar
But I'll
attorney
represent
should
to you
be
that earlier in your
disbarred for the
testimony, you
false
stated
statements they made in the
that-
complaint against him.
that the fact that President Trump instigated was viewed as a fact that was obvious on January 6th. Is that correct?
Would you like to go through the evidence, sir?
At the beginning, yes, it was, I would classify it as an obvious fact. It brought an operational part and informed the investigation. Clearly testified that.
So you're saying that it began as an obvious fact, it then became a hypothesis, and then it resulted in the same conclusion at the end of the committee's work. Is that correct?
No, it never changed because it was obvious from the events of the day there. It was the hypothesis that began the investigation, informing the proceeding. But I'm saying, as we always do in the investigation, yes, other facts can emerge and it never changed. The hypothesis was not related or disputed. So there's no evolution. But it was, to be clear, tested and plugged into a much more fulsome body of work beyond what been obvious at the time of those tweets and impeachments.
Okay. So, Mr. Hafey, you were appointed by President Obama as U.S. Attorney, correct?
Oh my God, Kat.
And President Obama was, and I believe still is, a Democrat, correct?
Yes, he is.
Okay. And you were appointed to the January 6th committee as an investigator by Representative Pelosi. Is that correct?
Well, Chair Thompson made a decision right next.
Speaker Pelosi, bitch.
Okay. And both former Speaker Pelosi and Representative Thompson, they were both Democrats, correct?
Yes, that's right.
Okay. Have you ever been appointed to a position by a Republican?
I don't think so. No.
Okay. In fact, you were fired. I'm sorry, did I cut you off? Please complete your question. I apologize.
When I talk about firing, I was reviewing in my position as University Council by a Republican Attorney General, defeated the incumbent Democrat. I was an Assistant Attorney General in the University Council, and where I explanation about over the objection of my client at the university, the new Republican Attorney General terminated my absence. Well, I was hoping it was.
Thank you, Mr. Hafey. You just saved me a few questions. I appreciate that.
I don't know what's up with the cap.
That openness.
I didn't know that either, Jim.
Mr. Hafey, you've made a number of political contributions over the years, correct?
Oh.
Okay. I'll see if we can short circuit a number of questions.
Have you met Harlan Crow?
Have you ever made contribution? Have you made any contributions to Democrats?
Hillary Clinton.
Yes.
In fact, almost, if not all, of your contributions have been to Democrats, correct?
I think so. I don't know, but I don't recall right now.
I'm sorry, did you say you don't recall making a contribution to a Republican?
I do not.
Okay.
I was trying to put it on the money when we ran percent. I just don't think I did.
What was the name of the person that you considered making a contribution to?
John was a staffer of Genesis. He left to run for secretary. I don't know if I can speak money or not.
Now he's being called out on donations.
So I may not have, but yeah, I know. So to be clear, I'm good about money to invest in the life.
Is she downing a monster?
Okay. Are you currently investigating or seeking the possibility of being appointed as a federal judge? Okay. Have you had any conversations with anyone about seeking a federal judicial appointment?
I have conversations with some people I'm not being a federal judge.
I didn't know that.
I am not insulted by that answer. It's a difficult job. One moment, please.
I don't have anything else. Oh my God.
Mr. Hafey, thank you very much for your
I
time
knew
today. I have no further questions right now.
Called it. Redirect. Let's go.
Yes, Your Honor. Mr. Hafey, I think you've answered this question, but you had answered in response to many questions about statements and tweets that have been issued in kind of the January 2021 timeframe that there were hypotheses that were tested. How are those hypotheses tested by the investigative staff on the January 6th committee?
We compared them to what we were hearing from our witnesses. We were seeing the documents from what we were learning from the other sources. Every investigation starts with a hypothesis. It's the nature of it. There's a suspect in a criminal investigation. Sometimes that's reinforced, sometimes it's rebutted. So, our answer to the question is that we approved everything we did was always plugging in, particularly synthesizing, and comparing it to our understanding of facts and circumstances.
And if you had found evidence that contradicted that hypothesis, what would you have done?
Absolutely, we would have found it as such. We would have made that clear. Yeah. When I was hired by the chairman, he gave me instruction that was reinforced throughout, which is follow the facts and circumstances wherever needed. And that's what we tried to do. We followed them. They ended up confirming the hypothesis, but that was a constant reassessment.
And after over a year of investigation and discussions with the numerous witnesses that you all had and the review of documents and video, what was and testing that hypothesis, what was the conclusion of the January 6th committee with regard to President Trump's culpability in the January 6th attack?
Well, over the course of our hearings, we found this fact of intentional multi-part plan led by the president and facilitated by him and others to disrupt the joint session. That is palpable throughout our communities.
And what were your conclusions about whether President Trump incited a violent insurrection on January 6th?
His incitement of violence was the final step of that multi-part prong to try to disrupt the transfer of power. We reinforced the hypothesis. It brought from just the words on the lips, fight like hell, or you're not in the country anymore, a much broader pattern, which inciting the violence was one final destination.
Now, there has been some suggestion that the January 6th committee was populated by Democrats and rhinos who had already prejudged President Trump's guilt. Are you familiar with other members of Congress who had also made statements in the weeks and months after the attack on January 6th regarding President Trump's culpability, including Republicans?
I believe our hearings featured statements by the McCarthy, Senate Minority McConnell, and other Republicans, essentially agreeing that the president board bears responsibility decided the violence. Those things came up soon after the events in the course of the impeachment.
Just waiting. You had mentioned that Speaker McCarthy said that President Trump, in the days after the attack, bore responsibility, correct?
You're going to get to this line of question. I asked him his understanding with respect to potential members, because we're talking about processes of the community, not processes of political that outside those kind of
Judge Rowland is pissed. at John Eastman's attorneys. Just
Yes.
so you know.
I think Speaker McCarthy or
Like she's so sick of them. I feel. I mean, ugh, it's hard. It's hard to watch.
Bring in hearsay to impeach, but I'm not sure that you can bring in hearsay to invalidate the impeachment. Plus, I really don't. So I'm going to sustain the objection.
That's fine, Your Honor. I'll move on. I think the point is made. You were asked some questions about Exhibit 1108, which was an article I think published earlier this year, which you gave some quotes, or at least there were some things you said that were quoted in. Do you recall that? And do you recall there being some effort to use the quotes from that article to suggest that the January 6th committee had somehow omitted key evidence?
Yes, I think Congresswoman Reed used a clip of a link to that interview to suggest the January 6th committee found that law enforcement was involved. And I provided that in my first and only series of tweets, and the only time I've ever actually tweeted something was a direct response.
It must be so hard to be a member of Congress these days.
Can we put
and
up
be amongst
Plaintiff's Exhibit 320?
such
please?
horrid people?
Your Honor, I guess I would object to this. The question was, did he agree with the statement in that article? He said no. Did not authenticate it, did not endorse it. And that was so again.
I think
He gets to
I think
ask
the
about
article was brought up to suggest that there were other, yes, exactly. Do you see Plaintiff's Exhibit 320? Was that one of the tweets, your 15 minutes of fame on Twitter, where you sent out a tweet following the publication of the article?
Objection. What? Wait, is that our guy? Why would he say that? Oh, is he mocking the other attorney?
My statements in that article, and yes, this looks like the first or one of the series of tweets that it looks like that's
Could you read this tweet, please?
Okay. I just have to laugh about this really quick because I don't know. I'm paying attention to this for other second. They're on a 10-minute recess, but John Eastman did not turn off his camera. And so it's just like a meme that says like the court is currently in recess, and then a tiny little box of John Eastman. And it's really funny.
It says, I recently spoke.
I'm waiting for him to start crying because he knows he lost.
Since that interview,
Come on. What are you looking at? What are you looking at, Mr. Eastman? What are you looking at? You tweeting? What are you doing?
He's calling
And finally,
Jack
I want to
Smith.
ask you some questions about
Joe, do you see that? Eastman forgot to turn off his camera.
To January 6th, following December 19th, and specifically,
I just see it says the court's in recess. What happened? He was on stage. He was still on?
Cross-examination, okay?
He forgot to turn off his camera. There's a little box of him on the right.
Was the committee ever able to discover or find out what specific intelligence was communicated to the president that the FBI had gathered?
No, unfortunately, we can't say how much, if any, of those guardians or other intelligence was briefed to the president. We did have testimony that during January 6th, the president was directly informed about the presence of weapons in the crowd. We had evidence the night before. He commented to White House staffers. The crowd is very angry. So there's some evidence. We awareness of the danger or potential for violence before his speech on the ellipse. But I can't say, Mr. President, that we were ever able to determine that he was trying to brief about any of that intelligence. That was one of the many things that we just could never get to the bottom of.
Was there some evidence about what Mr. Trump was told at the ellipse about individuals having weaponry?
Yes, in his testimony that he was told about weaponry, that he actually asked the magnetometer, saying to be quiet about her. That is very specifically made aware by staff of the
Kathy
president's
Eastman looks like he needs to vomit.
in crowd proposed actually bring weapons into.
So I want to look very quickly at one of the pages you were shown from Exhibit 1108. If we could go to page 9, please. And this will be the same, I think, quote from The Guardian, tipster that you were asked about. If you could blow up the second to last paragraph, please. And you recall being asked a question about this very specific or this very piece of evidence?
Yes.
And the tipster says they think they will have a large enough group to march into DC armed and will outnumber the police, so they can't be stopped. The quote goes on, they believe that since the election was stolen, that it's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is to literally kill. Please take this tip seriously and investigate further. You see that? And did you review the president's speech at the ellipse on January 6th as part of the investigation?
Yes, absolutely. Consistent message to the election stolen, constitutional rights to government, different rules apply.
Everybody gets the way it's
Let me put up speech, plaintiff's exhibit 1029, page 14. Blow up the top, please.
Didn't he say they're not here to hurt me or something? Eastman's gone now.
Oh, he realized.
Yeah, I think he's sending a WhatsApp to Jack Smith right now. Hey, Jack, want to have lunch? We can go to the Palm near DuPont Circle, you know, where, what's his name? The other idiotic lawyer and I sat and had a very loud conversation. Do you guys remember that? Do you remember that being reported in the news where, what was it? It was him and the other guy. Oh, fuck.
This is from
Scooter, no.
of the ellipse speech.
What's the name of their fucking weird lawyer that has all the white
Republicans
hair
have to be
and
tougher. You're not going to have a Republican Party
I'll
if you
find
don't
it.
get tougher.
I gotta
They
find
want
that.
to play
I
so
wonder what that
straight.
argument was
They want to
about.
play so, sir, yes, the United States, the Constitution doesn't allow me to send them back to the states. Well, I say, yes, it does. Because the Constitution says you have to protect our country. You have to protect our Constitution. And you can't vote on fraud. And fraud breaks up everything, doesn't it? When you catch somebody in a fraud, you're allowed to go by very different rules. How does that compare to that piece of intelligence taken from The Guardian and cited in Exhibit 1108?
Very, very close. The president repeatedly talked about the election being stolen without actual support, and did refer to the fact that the rules apply, saying that to an angry people on the list, incited violence.
No further questions.
Okay, let's recess until.
Okay.
Let's make it 3 or 5, so 20 minutes, and we'll finish up with.
So is this okay? So that's done.
Oh,
Oops.
sorry.
Whoops.
Thank you, Mr. President. Now, Mr. Jack is sitting all alone, it's really easy to forget you. It's like you're at the kids' table.
Okay, all right. Okay, this is great and everybody's fine. Okay, fine. Wow. Okay. So now, do you want to go? Do you guys have energy to go to another section of this, or I'm happy either way.
What is it? Is it guy? Is it the
I
guy?
think it's the idiot guy again. But let's go. Let me go to the main page and see if we can tell who's what. Hold on. Let's see here.
I mean, if it's cross examination, I'm always down for that. I don't
know.
want to hear
Yeah,
that.
that
I don't like that other attorney.
I don't like that. Part 1, no. All right, so this is, it's an hour, and this would have been the next part. So the part we started watching, which is drunk guy, and then there's part 5. Maybe we should just. Well, no.
Let's do it. Wait,
Let's do it the right way. God damn it! This is the next part after they came back from break. Got it?
Okay.
Okay, we're gonna. All right,
5
sit down. Everybody, sit down.
were last on the stand.
Here's the cross.
When we talked before lunch, we had just been discussing your testimony that Section 3 is ambiguous. And we finished talking about the meaning of the phrase insurrection. So now I want to turn our attention to your opinion about the meaning of the phrase engaged in insurrection.
Oh, camera dude.
Now, you recall talking about opinions by Attorney General Stanberry?
Yes.
And I believe you called Attorney General Stanberry's opinions good
the 5A.
evidence about the meaning of Section 3.
If you guys leave for the 5A, I totally understand.
Now, at the time that
Love
Attorney
you so
General
much.
Stanberry issued these opinions, that was in 1867, right?
Yes, before the ratification.
Thank you, Diana.
1868 was
You're so
before
sweet.
the states ratified Section 3, but after Congress had enacted legislation proposing Section 3 to the states, right?
Yes.
Let's pull up Attorney General Stanberry's first opinion. This is on page 788 of Professor Magliacca's appendix. You talked about how the Reconstruction Acts were established.
788 of an appendix. I
Look,
still like
yes.
so much.
The 6th section of the Reconstruction Acts provides, among other things, no person shall be eligible to any office under any such provisional governments who would be disqualified from holding office under the provisions of the 3rd article of said constitutional amendment, correct? So the Reconstruction Acts incorporated fully Section 3 of the 14th Amendment. The applicable language was identical, correct?
Yes, I'm sorry. Person shall be eligible to any office under any such provisional governments. Well, that's not the language of Section 3. He's talking there about this under 4 now the provisional governments.
Well, to be clear, though, this is saying that people would be disqualified from holding office under Section 3. And so when we're talking about engaged in insurrection or rebellion, that phrase was the phrase he was interpreting among others here, correct?
It's fair to to say that, well, the text of the statute itself,
Yes.
incorporates the jurisdictional provision of section 3.
Do you recall testifying in your direct examination about official versus individual capacity? And I think the point you were trying to make was that it wasn't totally clear what kinds of conduct were disqualifying in an official capacity versus in an individual capacity.
That seems to be separate.
I want to look at that discussion in Stanberry's opinion. If we go to page 799 of the appendix, there's a discussion here at the top. All those who in legislative or other official capacity were engaged in the furtherance of the common unlawful purpose, or persons who in their individual capacity have done any overt act for the purpose of promoting the rebellion, may well be said in the meaning of this law to have engaged in rebellion. Do you see that? And then the paragraph after that gives some examples of what might be considered engaging in rebellion in an official capacity. And then later on in that page, at the bottom, Stanberry says, so much for
stop doing that with your beard, dude.
what amounts to individual participation in the rebellion. Do you see that? And that's at the bottom of page 799. If we go to the top of page 799, and really that whole page is about individual participation in rebellion, correct?
I stroke my beard.
So you never read his.
Well, we just looked at the bottom of page 799.
And then what follows this?
Your Honor, may I approach the witness just to readjust the screen?
Oh my God. Can I touch the witness? Because, you know. I know, Rogue. It's the 7th. No, now we're on the 8th circle of hell. He has the longest lashes ever. Like, I just got lashes, but he's like crazy. I'm jealous.
Does that help, Professor?
I wish I had your lashes, Santa. I just want to call him Santa. He's like one of those creepy
So
Santas.
at the bottom of page 799, Attorney General Stanberry transitions from the subject of official participation to individual participation. Is that correct? And then the following page, page 800, there is a discussion of what it means to have engaged in individual participation in rebellion. And on page 799, Stanberry says it requires some direct overt act done with the intent to further the rebellion. Do you see that?
He says that's a necessary condition of being the party within the purview of the meeting.
Okay.
Sufficient is necessary.
Well, sir, later in that same passage, he says, but wherever an act is done voluntarily and in aid of the rebel cause, it would involve the person and it must work disqualification under this law. That was Attorney General Stanberry's interpretation, correct?
Oops.
I want to turn to page 804 of Professor Magliocca's appendix and just highlighting that now we're talking about Attorney General Stanberry's second opinion. Do you see that?
Yes.
And if we look at page 815 of that opinion,
It's a good one, Rogue.
I just wanted to direct your attention to the second from the bottom paragraph there, where Attorney General says that while forced contributions are not disqualifying, voluntary contributions to the rebel cause, even such indirect contributions as arise from the voluntary loan of money to rebel authorities or purchase of bonds or securities, would work disqualification, correct?
Are you talking about the second
Yes.
That's what he's asking.
And then later on that page, he specifically says, when a person has by speech or writing incited others to engage in rebellion, he must come under
Whoopsie.
correct?
But here he is talking about
Objection. That's bad for my client.
something to disqualification as because of their actions in an official capacity, discharge officers who are doing that discharge official duties, not incident like the ambassador, purported ambassador.
This guy fucking word salads it.
Those people
France.
are not, in his judgment, subject to disqualification in line of.
I don't even know what he's talking about.
Actions such as speech or writing that incite others.
You know, my dad was asked to leave the church when my brother was objecting to the Vietnam War. My brothers both. And I don't know if he was excommunicated formally, but the Monsignor basically.
Well, sir, the
disinvited
first
us.
sentence
And my
of
mom
this
was president
says
of the fucking
that
ladies'
officers
guild. Like, she was
during the
fucking
rebellion
serious
discharged
but
official
progressive
duties
Catholic.
not incident to war, but only such duties as belong to a state of peace and were necessary to the preservation of order and the administration of law are not to be considered as thereby engaging in rebellion or disqualified, correct?
I think what he has in mind there is that he's a law enforcement officials on the level of a constable, let's say, who are keeping peace in some country.
He looks like a robot.
And in doing peace,
A witch walk Oh my god. This is cute. I like the witch walk idea.
Correct. In the first sentence,
Yeah.
he's saying this is a class of persons that are not disqualified. And in the second sentence, he says, when a person has by speech or writing incited others to engage in rebellion, he must come under disqualification, correct?
That to refer to incitement by speech or writing in the discharge of.
I thought Opus Dei was fake.
But nowhere in that sentence does it say in the discharge of official duties, correct, sir? That's your interpretation, correct? In your report, you didn't discuss any of the
You're wrong,
pre-Civil War treason cases about incitement, did you? This is page 44 of Professor Magliacca's appendix, and here we're looking at charge to the grand jury treason from the circuit court in the Eastern District of Pennsylvania in 1851. Do you see that, sir? If we look at page 46, and by the way, this is from Judge Kane charging the grand jury. Judge Kane says, there has been, I fear, an erroneous impression on this subject among a portion of our people. If it has been thought safe to counsel and instigate others to acts of forcible opposition to the provisions of a statute, to inflame the minds of the ignorant by appeals to passion and denunciations of the law as oppressive, unjust, revolting to the conscience, and not binding on the actions of men, to represent the constitution of the land as a compact of iniquity, which it were meritorious to violate or subvert. The mistake has been a grievous one. Do you see that? And do you see at the end of that paragraph, Judge Kane instructs the grand jury that successfully to instigate treason is to commit it. But you didn't consider that in your report in this case, correct?
So if this case is relevant.
Did he show us his tits, Ivan?
Our section that does not appear to be an issue, and that is the part that refers to aid or comfort the enemy. So
Oh wow, licking his lips.
Insurrection or insurrection against the person.
Your opinion. Sorry, go ahead.
Show me where it comes back. insurrection other than the context of peace. Could we go back to the first page?
Let me just ask you a question. Is it your opinion that incitement was enough to have levied war against the United States for purposes of the treason clause? Let me finish. But was not enough to have engaged in insurrection under Section 3. Is that your opinion?
What did he say?
He can't answer straight questions.
Self-execution that you testified about on direct examination.
Well, this guy is like,
You
I
know
hate my
that
life
states
right now.
can enforce
He's gonna drink
federal
so
constitutional provisions through their own procedural rules, correct? That would include, for example, Section 1 of the 14th Amendment, right? Well, certainly a state could pass legislation providing remedies for violations of due process or equal protection, correct? There's nothing unconstitutional about that. You're not an expert in Colorado election law, fair to say? And you're not here to offer an opinion as to whether Colorado law grants a right of action to enforce federal constitutional qualifications in presidential primaries.
Oh my God.
Let's just briefly discuss Griffin's case.
I don't need
Griffin was
captions
convicted
for the
of a
lawyer.
crime in Virginia. Is that right?
I need captions.
And he was convicted of a crime by a state court judge who presumably was disqualified under Section 3. So then Griffin brought a federal habeas petition in federal court, arguing that his conviction should be overturned because the judge was disqualified under Section 3.
I didn't study that part of it.
And on direct examination, you said that Griffin's case had kind of 3 separate holdings. Do you recall that? One of the holdings denied habeas relief to Griffin on the basis of the de facto officer doctrine. Do you recall that? And as I understand it, the de facto officer doctrine essentially said this judge was in fact in that office at the time, even if perhaps not lawfully so. And we're not going to allow a collateral attack on the conviction of someone who was convicted by a de facto judicial officer. Was that the reasoning?
Essentially, yes.
And the court also denied
I don't know what
relief
you just
based
said,
on the
but I'm
scope
really
of
turned on right
habeas
now.
relief available under federal law, right?
Yes.
So just so we're all clear, Griffin's case did not involve a party invoking state procedural rules to enforce federal qualifications, correct? Do you know what year Griffin's case was decided?
It was decided in July of 1869.
That I did study.
What was the status of Virginia in 1869?
Well, there is another attorney general. I think it is the second that discusses powers of states not being agreed to the and the clear language is to the effect that the powers of the army and military are very circumscribed, but they are partial of the provincial government of the state and the provincial government. has
What?
Basically, all powers that unreconstructed state were to have, barring those that are expressly conferred on military.
But Virginia was under federal military occupation in 1869, right?
I don't know.
I didn't study that part.
I think so, but I'm not confirming.
And in fact, Virginia didn't get readmitted to the Union until 1870. Do you know that?
No, but I would say the presentation is correct.
Oh my God.
I want to turn to your opinion that Section 3 does not cover the president.
Well,
Oh, Well, the president is not an officer of the United States. That's your opinion, correct? Before this case, before you became an expert in this case, you had previously suggested that Section 3 does cover the presidency. Do you remember that?
What I said.
Probably about Barack Obama.
It depends.
Section 3 does not include the president as subject to section.
So is he saying that the president is above the law?
You addressed this issue in your op-ed in the Federalist in August of this year, correct? And in that op-ed, you said,
address this issue, case sentence in passing, basically to take it off the table by saying that you do not really want to discuss the issue.
Understood. And in that portion of your article, you said that although Section 3 does not explicitly refer to presidents or presidential candidates, comparison with other constitutional texts referring to officers supports the interpretation that it applies to the
Eastman's
presidency.
attorney is trying to convince the judge to extend
Were those
the
your
hearing.
words back in August? Your article from the Federalist in August of this year certainly didn't argue that the president was not covered by Section 3, right? You wrote that article in August of this year before you were hired by Donald Trump as a paid expert in this case, right?
Yes.
Since the time you wrote that article in the Federalist, you've been paid about $60,000 by Donald Trump for your work in this case?
And a lifetime supply of Capri Sun.
I want to pull up the language of Section 3 just so we're all clear on offices and officers. And let's start with offices. So no person shall hold any office, civil or military, under the United States if they are disqualified and have not received amnesty, correct? You agree that the presidency is an office under the United States, don't you?
I took a position on that. That is disputed. Scholars, I think, Professor Lash does not believe that
Dr. Bullwinkle?
that language applies to the presidency, as in all this other scholars. Maybe your tolerance it does. It is the subject, that language, the colloquy that I think the judge questioned about earlier, the colloquy between Senator Eric Johnson and Obama. So I have taken a position on whether the presidency as an office is covered or not.
So you're not going to tell us today whether the presidency is an office under the United States?
That's right. I haven't followed an opinion about that.
Well, sir, you know that
Aren't
the
you the
Constitution repeatedly refers to the office of the presidency, don't you?
That's one of the reasons I would be inclined to think that that language does apply to the office of the presidency.
You would be inclined to that view, or you don't know?
Oh my goodness.
Well, they're consistent statements.
Oh
Let's
my God.
look at
Did he just recount his
Petitioner's
own, or
Exhibit
retract his own
235.
testimony?
This is just the U.S. Constitution. And Article 2 is the portion of the Constitution that defines the powers of the presidency, right? Or at least one of them. And the executive branch.
Well,
I don't, he doesn't know.
United States, and does the president have powers?
Shut up.
No, I think
There wasn't
I'm
a
just saying that
question.
Article 2, at least in part, sets out the powers of the executive branch, correct?
Okay, there wasn't.
Yes, I'm trying to think whether Article 7 refers to the president, the presidency, responsibility to the president.
Understood, but I just want to highlight a little bit of language here in Article 2. In Section 1, It says that the president shall hold his office during the term of 4 years, right?
Yes.
And it refers to eligibility for the office of president
Yes.
and being eligible to that office.
Yes.
And it talks about the removal of the president
You
from
can ask Eastman more questions.
of that said office.
Shaming him not knowing.
And the president,
Oh,
in
yes.
fact, before he enters on the execution of his office, he has to take his oath, right?
That's right.
You know that the 12th Amendment also refers to the presidency as an office.
Yes.
And despite all that, you're not going to offer an opinion that the president of the United States.
Well, now this was worth it. Yikes. I really.
Well, let me ask you this. You agree it was well understood that Section 3 would not allow Jefferson Davis to become the president of the Union after the Civil War unless he got amnesty, right?
Well, if the language that we're discussing in Section 3, the disqualification or liability language, includes the office of the presidency, then Jefferson Davis would clearly have been disqualified from moving that office because, as I said, Mississippi and perhaps other connections, he had taken the Article 6 of the Constitution.
Correct. And you understand that after the Civil War, it was incredibly well understood that Jefferson Davis could not be the president of the Union unless he received amnesty, right? You recall seeing some of that evidence?
It was well understood. But there was yes, certainly was party inside. There's no question of that. And this was the party that Johnson raised and the Senator Lott sort of delay by pointing liability of his motivation.
I would push him into the zombie crowd.
And that colloquy that you're referring to, if we go to page 477 of Petitioner's Exhibit 144, this colloquy between Mr. Johnson and Mr. Morrill is what you're referring to?
Yes.
And you in your report said that this colloquy may tend to show that the presidency is an office covered by Section 3, right?
An office covered by the disqualification or liability language of Section 3.
And you would agree that in the debates about amnesty after the Civil War, one of the main arguments against blanket amnesty was that it would be absurd to allow Jefferson Davis to be the president of the United States. And if you granted amnesty for everybody under Section 3, then Jefferson Davis would become eligible to be president. Have you seen all that historical evidence?
Well, people thought that they would have been wrong if the office of the presidency is covered by the language that Senator Morrill quotes. Whatever they thought, he would have been disqualified.
What?
Yes, and
because he falls within the jurisdictional element of Section 3.
What?
Which is having taken an oath to support the Constitution.
What?
So even though everybody at the time knew that Section 3 disqualified Jefferson Davis to be president, you don't think that's good enough evidence to take a position as to whether or not the presidency is an office that is covered by Section 3?
Because this is a matter of active scholarly dispute. Professor Flash and Professors Blackman and Tillman do not think that the language which the conservatives comprehends the presidency.
And they also don't think it's enough that the presidency is referred to it as an office about a dozen times in the Constitution. Let's talk about oaths.
I prefer mine to be.
I believe you testified on direct that you thought there's a
Thanks,
difference
Rebecca.
between an
Lurker's
oath to
always
support
welcome.
the
Thanks for checking
Constitution of the United States and the president's oath. Do you recall that testimony? And I believe you said that the president's oath to preserve, protect, and whatever else it says isn't an oath to support the Constitution, right?
Obviously, this is actually a different oath. That is a different article of the Constitution as well.
Okay, it's preserve, protect, and defend the Constitution, right? That's what the president has to do.
As he is required to take that oath, and I'm having taken it to carry it out.
And they use different words, but you would certainly agree with me that preserving, protecting, or defending the Constitution of the United States as a practical matter includes an obligation to support it, right?
I don't think it's relevant whether as a practical matter it requires to support the Constitution. As a practical matter, sure, but we're not talking about practical matters. We're talking about the actual language of the Constitution, the actual language of Article 6 is how.
Well, what is the spirit
of
the 14th Amendment, Section 3?
And sir, are you going to take the position? Well, strike that. Preserving, protecting, and defending the Constitution of the United States may not be limited to supporting it, but certainly includes supporting the Constitution, right?
As a practical matter.
No,
Yes,
as a matter of law.
The relevance of that because constitutional language is crafted carefully and precisely so as to achieve.
Right, Max? So
not believe that the framers of Section 3 were carried in their passage. It may be that there are some formulations of the Articles 6 oath or feasibility that vary linguistically slightly, but there's a powerful difference between the language of the Article 2 oath and the language of the Article 6 oath. I think that linguistic difference, which is a substantial, supports the view that the president is not comprehended under the disqualification of Section 3 because he does not.
So
Lolo.
he says that Jefferson Davis should have been able to run. Is that what your position is, sir? Yes, go ahead. Gal, sorry.
That has ever since George Washington was inaugurated.
No, I have to interrupt because I'm literally watching John Eastman nearly hold back tears while he's being raked over the coals by Judge Rowland.
In some of the historical research
it's like,
done in the past, you've looked at
it's
a
bad. I almost feel bad for him because I'm that kind of person.
And you cited Samuel Johnson because that dictionary in the late 1700s was considered kind of one of the gold standards for lexicography and definition, right?
Yes, it's maybe not unique, but dictionary of English language.
All right, so let's pull up Petitioner's Exhibit 280.
His entire life right now is slipping from his grip, and you're watching it happen.
I will represent to
Can you pause this, Lolo? I mean, it's really, and can you just pause it for a second?
I want to look at how.
Joe, are you seeing this?
Yeah.
Can you describe it? Are you seeing what I'm seeing?
It's going on and on and on.
So is she basically delivering any kind of judgment right now, or is it just?
Well,
She
go
said,
ahead. Sorry.
I guess that one of the things that the Eastman's lawyer wanted to do was put on a surrebuttal case, which is basically a secondary rebuttal case, and she won't allow it. First, it's in her discretion whether to allow it or not. And second, the only reason that they should allow it is if any new information had come in on any of the information for the rebuttal cases. One of the things that should have happened is either if you want to put on your rebuttal case, then you can do that through cross-examination of witnesses.
Yep.
Eastman's been on the stand about 600 or 700 times now, and it's the same thing over and over and over again. Nothing is new that's coming out. Nothing at all. His position hasn't changed. His talking points haven't changed. Nothing is new. Nothing is different. And I think, we are getting to that point now where, we're talking about, I can't imagine how much time she's going to give them for closing arguments, because all of this has been closing arguments. OCTC, we know what their closing arguments are going to be. We know what Eastman's closing arguments are going to be. It's just a matter of, can we just rip this Band-Aid off and stop? I mean, it is painful to watch this. I mean, you are, like you said, Gal, I mean,
It's so painful.
this is somebody who's and it's not even, they're slow walking this, you know. I mean, just be done. Just let her get to her 100 and some odd page ruling, because it's going to be an enormous ruling. Just let her start, you know.
And his attorneys know where she's going.
Yeah.
They are doing this to him, and they're not even acknowledging and recognizing that they've lost.
Yeah.
They have fucking. I mean, this is like the epitome of what Trump did, and it is it's poetic, to be honest. It's poetic that the attorney that couldn't tell Trump you lost can't tell himself he lost. They have lost, and he cannot let go. He cannot let go. And I can understand. I mean, you work your entire life, and it's like it's a long process to get a Juris Doctorate and a PhD and you know, become, like, even if it's a right wing or a whatever, a constitutional scholar, that's a huge accomplishment in life. And that is being literally slipping through his fingertips this week and today especially, and he can't let go.
And his attorney is not helping, and you know, just not helping matters. And what they're doing is, and they're making you know, she keeps saying, making a record. You've made your record. You've made your record. All that is about appeal. So he's not even trying this case. He's trying the appeal case. You know, he's trying to get this to the appeal. They know that this is going to appeal. That's why
they know
making
that.
Think about the record and making sure that it's so clear and that they have all these things, because these are going to be things, you know, he's going to argue on appeal that the judge ruled that, you know, he wasn't able to put on a rebuttal case, right? So now that can get spun into, well, the judge isn't allowing evidence in on Eastman's behalf and all these other things, not taking into account the fact that we've been at this for, you know, over 30 days.
Yeah. Almost 45. And
I mean, between this in 1 year and this guy on the screen in the other, I'm actively unlearning.
Well, and it really just shows that there is no there yet again in stark color. And he, to me, is a huge domino to fall, because he is falling on his sword. And if you listen to right-wing media talking points, they're still parroting the same stuff. So they're clearly not watching this be torn apart at the seams. But they're not accepting the fact that we see now what's behind the curtain. And although it's still very murky and detailed and convoluted, it will not remain that way. And it will become a narrative. And I think Eastman is beginning to realize, and he gets up on the stand and he says the same things as if, well, I'll just keep saying this until you believe me. I mean, he really is that ironic. It's an incredible case. It's actually a shame that this one, I understand the reasons for them not putting them out again, on a reporting basis, but this one is, I thought because I watched Rudy's disbarment, and I
did too. Yeah,
this one was good. Like, it was very good at some crucial information.
The reason sorry, I didn't mean to interrupt you.
Go ahead.
No, I just think the reason I think this one is because John Eastman believed he could put on the evidence of election fraud, and I think that was a grave mistake. I think what he attempted to do was utilize this procedure or this process to present the evidence that he had been declaring had not been reviewed. Yeah. And I think that was a grave mistake. Yeah. A grave mistake.
But think about what you just said. Sorry, Joe. Think about what you just said. I just want to get this out there, and then Joe weighed on it too. He's a fucking constitutional expert lawyer. His entire career has probably built up to the moment where he was asked by the president, give me all your legal theories about, you know, how I stay in power or whatever, however that question was posed to him and by whomever.
Right.
This is the penultimate case for him. You know what I mean? It's almost like the mad scientist. Like when we watch the thing.
Totally. You are so on the fucking target. Please keep going.
He's the mad scientist that wanted to go down in history as the dude who solved a major constitutional question. His ego got him. 'Twas beauty killed the beast. He fucking gave into his fucking dick sucking. He sucked his own dick. And it was not great. So I mean that's kind of shocking for someone who has that much worldliness and
and intellectual ability. He really, I mean, he's a smart person.
He's not a dummy.
Like, I can't, yeah.
I mean, but when he talks, he sounds kind of dumb. Anyway, sorry. Go ahead, Joe. What are your thoughts?
I can't remember.
Okay, I'm sorry. I do that all the time. God damn it. No, it's been a very long day. Okay. So
to me, it's just like I just feel like, and it's almost, see, this is why I'm bad at like being a liar or being deceptive, is because I genuinely have empathy for him in this moment. I really do. And I don't even enjoy saying that because I know what his purpose and malicious intent was, but I don't ever want to see anybody, like, the anguish on his face is like, it's palpable. Like, it's hard to watch somebody deteriorate and like throw away their entire legacy because they thought they were better than others.
Yep.
Because they thought that they should be in control of things because they were smarter or better or faster or whatever. And, it's like, yeah, they should get what they deserve and da-da-da-da. But at the same time, it's like, that's why they're not better, is because they actually wish pain and suffering and hurt on other people. And I just don't. So I don't like seeing people in those moments of anguish that I can clearly read on him, and I don't know, I have empathy for these situations because I can't imagine being in my 60s and about to lose a legacy, that's hard. It has to be hard, and by the hands of a woman when you're an anti-feminist fucking misogynist. True. Like, that's very, I mean, it's great, like, in juxtaposition to everything. Yeah. But at the same time, like, yeah, but if I put myself in that empathy space, it's,
well,
whatever. I know nobody likes to feel
but
sorry for these guys. I don't feel sorry. That's different. I don't feel sorry.
But you can feel his humiliation. And anyone with a heart can sense when someone's being publicly humiliated, it's a little cringy, right? It's a little like, oh, yeah, okay. But at the same time, he did bring it on himself. And the thing about him is that sure. I do think he's a true believer and he's about to be left out in the cold. So the next steps for him, I think, are going to be so interesting. I just don't know what his moves can be. I don't know how many.
Here's what I predict, that he's feeling this in the moment, but he's going to be one of those people who live in utter denial forever.
Like Rudy.
That it was not his fault. It was somebody else. It's always somebody else. So that's where my empathy will then drop away again. But like,
which he did do, right? Well, Cheese Bro told me this, and so told me that, and you told me, so he did blame it. Yeah. He didn't check any of the data.
He deserves to have his bar license removed. He deserves all of this penalty. He deserves to be indicted. He deserves to have his day in court. All of these things. So, I mean, none of those things change as far as like, how I'm watching this, but holy cow. I mean, he's really, she is just shooting him down. She is just telling him and his attorneys, like, we're done with that. I have heard it and heard it and heard it. And what you're saying, it just doesn't matter to what the context of what we're looking at here is.
Do you think Claremont?
she's really been a model judge. This is what you want to judge.
Yes.
She's not getting into back and forth with them, and she's remained calm the whole time. She's absolutely in control. And I think
That's
you
great
said it
question.
earlier too about sort of the overarching misogyny in the room, if you will. There have been witnesses that have come in thinking who they are and thinking that they're going to be in charge of this courtroom, and she's completely destroyed all of that and said, this is
Yes.
my courtroom. She has been in charge. And I think, again, when we talk about narratives, you can almost see it being written as we're going.
Yeah.
They won't let us put on our case. Okay, well, it's a woman who won't do it. So there you go. Women judges, what can you do? And, again, and I think you said it, yesterday, that it's the women that have been holding this down.
Right.
They've been at the forefront of all the good things that we've had to,
All the progress, really.
Yeah.
Every major kind of money move has been at the mostly
Yeah.
at the women. It's so true. And the thing about there was something that you said, Joe, that made me think about Eastman. Okay, it'll come to me. Well, shall we finish up with this dude, or are you guys just about done for the day? It's up to you. I'll need to take a break before a trivia session, and actually I might indulge people and ask them if we can do the lounge tomorrow night, just so I can be fresh and fruity.
I would do tomorrow night. If you
Tomorrow night.
can.
Yeah. Oh, I definitely can. Yeah, no problem. I can do it. No problem.
I would say see, the thing that I like about what's happening in Colorado is it provides some really good educational context for the term insurrection. It provides us as people who are attempting to be persuasive even at times to say it was an insurrection, and how do we present that in the appropriate way that isn't combative, but it is demonstrative of what happened. And so I feel like Colorado really provides that educational element of what our friends over at Crew are doing. Is they are literally just orchestrating this beautiful lecture on the Constitution,
Yeah.
and it's so informational, even as entertaining as it can be with this doofus trying to walk around words and things. But I still think it's worth watching, but I'm glued to John Eastman's face. I'm having trouble.
Well, go ahead. No, let's continue then, and
with
continue
both.
to talk about it. And here's the oh gosh, you just said something too. God damn it, my brain is like.
Because that's the thing is, this one, Eastman, she wants to be done tonight.
Yeah.
She wants to be done, and Joe's right. I feel like his okay. So riddle me this, Joe. It has felt as if this has been by Eastman and his team intentionally strung along because they understand that it's not just about his bar license. Inevitably, once this is done, he has to face the music in Georgia. Then he's going to have to face the music with Jack Smith. And that is, I think, what we're not only watching this person who's life's work is essentially slipping through his fingertips, but the next thing he has to grab hold of is his freedom.
Yeah.
And he doesn't. Yeah.
This is the soft open, and I think with the timing of this is going to be interesting. I haven't done the math yet, but the way that this is going to go from here, once they conclude whatever closing arguments they'll have today, this case won't actually be submitted. I think they'll have post trial motions, if any, and then whatever filings they may have after they close this. And then I think they have 21 days. I think she gave them 21 days to respond with that. And then I think it'll be another few days for her to actually render her opinion, because obviously, she's going to have to write it and she's going to have to put it all together. and it's a lot. I mean, this is a lot of testimony. The guy was asking Heafy earlier about, did you have a lot of documents in your hearings and grand juries activities? I mean, look at all the binders behind Judge Rowland. There's like 100 binders behind her.
Exactly, with thousands.
These are like 4 or 5 inch binders, just to give context for people.
There's so many pages of information that's in the record here, and you're right. I think what happens next is once that opinion comes out, then I think what'll happen is that's when I think the news will start to pick up on it, right? Because they'll have a document they can point to. They'll be able to look at her opinion and they'll be able to say, this is what the judge said in this case.
All right, crazy Ivan.
And I think when that happens, that's when people will start to really pay attention and say, wait, what was happening? A judge said that, so there's going to be this entire time between, tonight when it's over and the period in which it gets submitted to the court and the court rules on it and puts out her opinion in writing. That window is the spin window. That's going to be the window where they can get as much of the message out that they can without interference of the truth, right? The truth isn't going to be here until her ruling is there. Once her ruling comes out, the truth arrives, right? Then it's finalized. It is what it is. We have something that we can point to. The media will point to it. People will start to pay attention. But at that point, we're into December, maybe.
Tomorrow night, don't go. And
yeah,
do you believe
this
that
has been the problem with the live stream situation too?
Do you think do you think he starts to lose any of the affiliations like Tom Klingenstein at the Claremont or whatever his name is?
What was your question?
My question is, do you think that Eastman is going to lose kind of the colleagues?
No, no.
Claremont won't.
No.
His ass.
No, because their entire existence relies upon there being a covert, shadowy deep state that is out to get and silence conservatives and take their livelihood and take their ability to make money and all of this. So it's never going to end. It just doesn't end, and so it's like, that's what, when Joe says the spin is going to be, it's going to be wild. I mean, it really is, which is why it's unfortunate that, I'm a rule follower, because I would love to put clips of this out. I mean, there have been moments in here where it's like, I've just thought to myself, like, people need to hear this, because even when her written ruling comes out, I mean, look at the freaking witnesses they've called in Colorado haven't read the entirety of the January 6th committee report. Like, people just don't take the time to learn things. They just want to be told the cliff notes, and shit like this is just something you have to see to believe and understand. Even her ruling, though it will be the truth, and I'm sure it will be impressive, it won't hit the way it hits when you're watching it,
Then we need to put it in musical form. That's what we're going to do. We're going to act it out, kids. We're going to put a show on in the barn.
No, that's not a terrible idea. I mean, honestly, one of the things that I want to do is literally read the transcripts, right? Like, find.
That's what we've been. Oh my gosh! Yes,
what are the most important transcripts that we need to understand and read, and then just literally read it. So, like,
let's go through the timeline.
I can't do I can't do the female voices, so if anybody's interested.
Me, I'm on it. Let's do it. Let's do it. I've been saying this. How long have I been saying this, Lolo? How long have I been saying this? I have forced these girls to do this with me on a multiple occasion.
Whatever you need, however you want to do it, I'm in.
Okay.
Tell me what you need, because this is what I want to do, and this is great. I'm in.
I appreciate that, and like I said, I think that we in some ways, there's just too many documents that are sitting there gathering dust, and we need to bring life to them, because there are. I think if people read Kelly Sorrell's testimony,
Oh my God, yeah.
I mean, Kelly Sorrell's testimony was riveting, absolutely riveting. And no one's talked about it.
She blocked me on Twitter. I think I made a sex joke.
Is
about
she? Wasn't she rendered unable to stand for trial?
I think so.
Oh, unable to stand for trial. Like,
yeah, mental health.
Oh shit. Oh,
Right, Joe? Is that what happened?
I think
Because
that's
she was charged with sedition.
I think. Well, I think she was indicted, but like you said, I don't think she ever went to trial. I don't know if there was a ruling, like a written ruling, saying that she was found mentally incompetent. I'm not sure on that, but I do remember hearing something about that.
I did not realize that. Oh, I'll have to take a look at that. Yeah, incompetent maybe, but not.
But even that, it's interesting because if that's the case, then you wonder, I mean, I don't know that she'd make a great public witness, so I'm not surprised that the January 6th committee didn't call her, because you don't know what you're going to get, like it's live and anything can happen. And her testimony is a little bit, it's a little bit out there, but it's the out there that we need to understand, because that out there is their reality, right? That out there is not out there to them. It's the reality they live within. I mean, she was part of, the affidavits, right? So gathering affidavits and working with affidavits in Michigan, that information should be, drilled into a little bit more. Like, who are you working for, right? Who asked you to do that work?
Right.
Wow. So I think her testimony is important for people to hear. I think, even though it wasn't under oath, I think Jenny Thomas's testimony is important for people to hear, just because her name is there all the time, and and I think people don't necessarily have an understanding of, what it was she was doing on January 6th, which was sounded like this walking tour of the city. Like she just, kind of, said, okay, I'm gonna, put on a light coat and go for a stroll. And it's, it's like, really? That's what you decided to do that day. And the fact is, here's everything, guys, and I'm out. don't call me for a month. But it's like the most crucial month, People don't know that.
Because she was too busy planning all the buses and shit. Come on now. She had a lot to do. Busy lady. Messy bun, get stuff done, right? Am I right?
Ali Alexander is another one that, that testimony is important.
Oh.
I mean, even, it's you think about somebody sitting for a deposition for 8 hours, right? To read it, it's going to take 8 hours. But I think that there are certain portions of it that, if read, will at least help to start build a foundation for what people to know as we start to go up.
Yeah, and I'd kind of like to start with the second part of the Mueller report. if we're gonna be honest about it, I've been listening to someone read that. I think I certainly have documents, and I know I don't even want to say about what Gal and Clay and Jay Rance and Tina have. Jesus Christ, there might be a whole national archive. Then plus whatever I know there's probably a lot of collective wisdom about the documents. And have you identified other things? Like, I know Ali Alexander, do you have like a list going, Joe, or how far down?
Whose transcript I think people probably need to read, and it's a really interesting one, is Thomas Special. Yes. He actually voluntarily went into the committee. They didn't even subpoena him.
I'm sorry,
he went in there.
Service or no? Sorry.
Do you know Joe?
No.
He was Veterans for Trump, right?
Yeah, Vets for Trump.
Oh,
right.
Okay. All right. Sorry.
Which, I don't know if you guys remember, but even in the volume 5 of the Senate intelligence report, there was mentions of Vets for Trump in that.
Oh, in the Russia one?
Yes. Volume 5.
Yeah, and see, if you remember Tom Special, or I don't know how you say his name, on January 6th, he was on Russian state-owned TV interviewing on the steps of the Capitol.
Was he just being interviewed, or was he like a correspondent?
Well, he was being interviewed, but they sure knew to talk to him. And you have to understand that Ivan Raiklin was running around with him for months and months and months leading up to January 6th. And I think they were in Pennsylvania quite a bit, which is where Charles Bausman, who Joe and I have done a lot of work on, that's where he literally fled to Moscow, like days after the insurrection, leaving his properties, doing nothing with them, Christmas lights up and all.
Jeez. Well, you better not stay near any windows.
But anyways, Thomas's transcript it's incredible. So you know how we've been talking about Eastman and these guys who come in here and they just think, oh, I'm hot shit and I'm smarter than you and I know more than you and I'm better than you and all these things. His testimony or his transcript reads like that. It reads like, I'm just going to come in here and I'm going to tell you what it is and you're going to believe me because it was just so arrogant and deceptive, and it's just a very interesting testimony. The other transcript that is so crucial is Ginny Thomas. Hers is so crucial.
When we read,
I made the girls read part of it with me because it's just so. She admits so much in there that with context. The picture really emerges. The people she was emailing, the sentiments she had with specific questions. She talks about the 79 days plan in it. She talks about how it was like a masterful plan, that it was so well done by this team of, constitutional scholars. And it's just so, illustrative of what we're up against,
And also to who those scholars are, right? You're talking about people like Eastman, right? So again, she's kind of in this, bubble of these organizations, all these grassroots organizations, and it's the same lawn, right? It's all the same. The same people keep showing up. I don't know how many times we've said it, but the same people keep showing up all the time in different places.
When they get on the stand, their story falls apart. And that's it. And it's just a matter of getting them on the stand.
Mm-hmm. Well, and I think too, what Joe probably, I don't know if I'm sure he'd probably agree, but it's like they focus on the, catchy, well-known names because they don't want to take time to introduce them to an audience and explain who they are or whatever. And I just feel like the meat and potatoes of what was behind January 6th and what is still in the works today, when we look at like Project 2025 and some of these bad actors, and now we have Mike Johnson and all these things, they're missing. Oh, sorry, my son's asking me something. Hold on.
Yeah, they're missing the lead. The one thing too, Gal, about what you said earlier was these cases are giving us a shared vocabulary and making sure that the definitions, it almost is saving time in the more vital to national security cases coming down the road. So I think it is important.
Sorry about that.
No, not at all.
We're picking a movie for movie night, my babies, but I know they're so cute. But yeah, so I just, these are the things Joe knows because he's dug into those, when we look at things, and I think, I was thinking about it earlier when we were talking, it's like, a lot of people wanted to focus on like the rioters and the, people that broke in and da-da-da-da. But when I started looking at that, I think originally right after the insurrection, but then I just kind of that empathy kind of kicked in and I was like, who fucking sent them there? Why did these people feel so compelled to throw away their lives? And these aren't people who typically, there are some instances, but most of them were not rule breakers. They weren't criminals, right? In regular everyday mindset. They really did think they supported police. They really did think that they were, for the Constitution and da 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 da. So who sent them there and basically told them to abandon all principles that they have had and their values and moral structure for so long, their entire lives? And who sent them there and told them to throw that all away?
You know,
And for what?
I'm hoping that the Smartmatic case will tell us that, right? I mean, if
Oh,
if
yeah.
remember, Dominion had Fox, right? They had that lawsuit, and it was going forward until they settled. That settlement really kind of put a lot of things, to the side, because there was a lot of those answers may have come out there. Like, you
Yep.
told your audience of however many million people a night, that these things were happening, and were they true? Right? I mean, those kind of questions all could have been asked of people who were on-air personalities. They could have said, "Did you know it wasn't true?" But now that they settled and will not know. But if the Smartmatic case goes forward and they decide that they're going to take it all the way to trial, that'll be informative as well.
I can't wait. Have they paid? Has Fox paid? I guess they appeal that shit. What about Mike Pillow? I haven't checked in on him lately. Do we know if he's still, do we have any proof of life? Little Mikey Lindell. I got to check in on him. I've ignored him. I'll spend some time with him in the war room tomorrow. Wow. Okay. Would we like to continue watching the end of this? I'm willing if you guys are, or if you're like, I'm done, I'm spent.
Yeah, I'm burnt. I'm going to have to jump off.
Let's do it. Let's go ahead and wrap it. And we can listen. I would like to listen to the rest of this. And then there's one more 40-minute segment at the end of the day. So I'll find a time when we can kind of play that again. But, Lindell posted a video saying he's going to send one of those devices to my county. Yeah, those are things where there are people that are going to sign up at Cause for America, which is a horrible organization that is affiliated with Mike Lindell, but is like Ash Ebb and all these other horrible people. And their intention is to basically poison the local election systems with their kind of operatives. And one of their operatives is this little device that basically pings people in the immediate area who have signed up for alerts. I'm shitting you not right now. If you sign up for alerts at whatever, if one of the jackasses walks into a polling place and his device or her device picks up a wireless signal or a modem or whatever.
Yeah, just a Wi-Fi signal. That's all.
If it picks up a Wi-Fi signal, it sends an alert to everyone who has signed up for alerts in that area.
In the area.
So that they can
and
run
tells them which polling location.
Yes. This is his little bit. Now, is it going to work? No. But
no.
That's not the point. The point is this is stochastic terrorism, and Mike Lindell is fomenting it and giving it a device and bankrolled it.
And that's that stochastic terrorism is so true when you think about what they've said in the Eastman trial today under the aggravation part of it. They were trying to talk about the harm that was done based on what was out there for people to question about the election, and talking about all the emails and phone calls that people were getting.
The threats to election workers, yeah.
Yeah, it came about because people heard these things and were, like you said, thinking they were doing the right thing, which I don't know how sending, an email to some, poor state, Secretary of State's office worker, saying some of the things that they've said is helpful, but they felt they were helping. Yeah. They said, well, we can't connect anything that Eastman said to those things. And they're right. Not direct connection, but I mean, at some point, you have to think people are going to, act on some of the things that are being said. And sometimes I think in certain cases, depending on who's saying it, they may be hoping for that result, and that's not right either.
Absolutely. As evidenced by situations that we've seen, and when certain people, last name Flynn, celebrate when certain things happen and point them out.
Wow. I think multiple gag orders on the guy who's saying a lot of this stuff is that's pretty telling. Like, they're and it's so interesting too with the fact that a lot of the vitriol is going towards, some of the people in the New York case.
Right.
Because I think that, to me, if there was anything that he cared about, he cares about the brand. He cares about the Trump name. And
Right.
that's what's at risk there. Not, the freedom doesn't matter because he can use that to his advantage. Nothing else matters. The kids don't matter. What matters is how he feels about his own feelings in the moment.
Yeah, his
Dangerous.
what he perceives his public image and social capital to be. That is actually more important to him. Did you guys?
Yeah, well,
Eric Trump.
I gotta get the kiddos
Okay.
situated. So can you timestamp this one that we're watching so we can pick it back up
Definitely.
soon? Yeah,
We'll definitely do that.
that'll be awesome.
Thanks, Gal. Thank you, Joe. Thank you so much.
Thank you.
Thank you.
I'll be around later once I
No
get them
worries.
snuggled in.
All right. All right. Well,
Thanks for
thanks
allowing
again.
for the space here, Lolo. It's really,
Oh,
it's really
goodness.
important.
Oh, I'm so grateful. And you guys just made it umpteen times better. And of course, the chat, as always, are the most amazing, smartest, funniest. And I'm also so grateful that you guys come back and spend so much time. So thank you very much. All right.
Thank you.
Till tomorrow night. Everyone have a wonderful night.
Bye.
Happy Friday.
Woo!